Malad, I am seeking leave of your lordship, Malad, item number 59 for upgradation. Malad, it cannot wait, Malad.
Wait. Don't mention it for upgradation.
The group
Only application.
Group
don't
2
give it for
application.
him.
Group 2 application.
Only application.
Group 2
Don't give anything for him.
With you.
Well, Lord, granted me leave on Thursday to file these applications without certified copy. I've done that. But this is extremely urgent, my Lord.
We shall see to it. We
Well,
can- All matters are extremely
I tell you, Lordship, the Honorable Single Judge is directed.
Please call
My lord, only one thing. Your
Well, this
lordship
let-
directed to submit the law notes. My lord, in
No, let this be included. I filed it.
Yes.
Lordship.
law notes, your lordship directed to
LGPH లో Thursday include
Matter, which matter?
My lord, in that upper primary matter, my lord, where your lordship directed for publication of the panel, your lordship kept those matter on 14th of September. Monday, your lordship directed to submit the law notes.
Yes.
My lord, may I be permitted to mention with regard to 159, my lord.
Sorry, nothing. No, this is matter mentioned.
Well,
Call the
can
list,
some
call the list,
precedence
call
be
the
given
list.
to this? These are-
Call the list.
item number 1 notice লিখে দিয়েছেন
When the order was passed.
Order was 28th of August, my lord.
Well, give it. Yes, call the list, yes.
Malad, in this matter, I have for the appellant.
number 1
Malad, we have discovered one document which I want to file. Why we have additional evidence in this
No,
proceeding.
who is your other side?
Well, I am praying only matter be taken up on Friday, Malad. In the meantime, we shall serve the notice and matter be taken up by lordship. A very important document, Malad,
Very
regarding
important.
but at least, Malad, a drowning man always tries to get hold of the straw. Well, that is how, Malad, I am trying, Malad, desperately for this. Malad, we have got a document, Malad, to support our
Other
case.
side. Who is your other side?
lordship may I
Samuel Badi, Malad, I shall give the notice to Mr. Badi.
Stay down.
lordship may I permit
Mr. The state respondents are not represented. Full stop. Mr. Kamalesh Bhattacharya, the land counsel representing the appellants, has submitted that
Lordship, may I permitted to mention, Lordship, may I permitted to mention
bolo,
the
bolo,
matter
bolo.
for inclusion of a mandamus appeal.
yes.
Lordship, may I permitted to mention the matter for inclusion of a mandamus appeal.
We are not including any hearing matter now for the time being. Yes, next.
Is item number 2.
Well, I am appearing with my advocate record, Mr. Sukumar Sarkar. My client instructed not to proceed with the
Take
matter.
down. Yes.
Not to.
On the original letter of instruction being produced on behalf of the appellant, disclosing her desire,
Seventh.
Bring for a short passover, my lord, in this matter. That is obviously on his way.
pass it over once. Next. Next matter.
Item number 4.
কত পেজে আছে বলে স্টেট রেসপন্স
Just pass it over once. Next.
Huh?
Call. Should take it.
Item number 5.
Take it.
6.
for the state my lord.
Yes.
7.
7-1, I am for the appellant. Admittedly, the petitioner challenged the order of Director of School Education of 2011, now 2013, and 2023. Materially, matter is infructuous due to influx of time, infructuous. But it should be your lordship's order that due to influx of time, the matter is infructuous. That I am praying. Otherwise, the client may come and say, how you are said on my behalf. Practically nothing is there. Primary teachers case now TET has come. NCT the primary qualification has been changed. So practically nothing is there. I am for the petitioner, but practically your lordship kindly pass the order. The matter is infructuous due to 1 marks was not given in 2011 for primary selection. Then TET has come in 1914. Even NCT qualification has been changed. So practically nothing is there. An order of
But
justice.
have you served upon the respondents notice? You are directed, Mr. Shubir Hajra.
Yes,
appeared for
well,
the
you are
appellant.
directed, but since we are not praying,
No, then we have to record that you are not pressing this. Don't
Under
leave it to
that
the
side-
court. Don't leave it to the court. You may
No,
take the
I'm-
decision.
then I'm mentioning, I'm praying because on merit I'm also mentioning. Oh, that's why your lordship is want to serve.
Yes.
Only if your lordship pass that order, that will practical. Otherwise, but kindly see the order of justice stand on dated 11th March, 18th March 2011. Now 2013, 2023. One marks was not given, the matter sent back to the director of school education. Director of school education also said that no, 1 mark should not be given.
Not happy to do it.
সে বুঝে যাবে, বলছে আমার উপর দিয়ে তুমি কোর্টের উপর দিয়ে করছো, তুমি নিজে নোট প্রেস করলো তো। Now the employment policy has already been changed regarding primary teachers.
Take down. You have heard the learned counsel for the appellant. In view of the clear assertion of the Rabindra Bharati University that Nikhil Bharat Sangeet Parishad is not affiliated, the question of awarding 1 mark as a
করতে পারি
credit.
ওটাই তো কি করবো এটা জিনিস
Under
তো
such
ডিফল্ট করা
circumstances, we are not inclined to interfere with the order passed by the learned single judge. The appeal is dismissed. Next,
আম গেটফুল ম্যান
next.
ওইটা কত আছে আরে কত আছে আমরা এসেছি
Next,
Item number 8.
I am appearing on behalf of the state.
Please, my lamp was a petitioner led by Mr. Bari, my lord.
yes, give the paper.
I'm praying for short passover, my lord.
Yes, pass it over once. No second time pass over.
Yes, my lord.
That's all the list.
9.
But item number 9, my lord, I'm for the appellant.
Very
Your
well,
lordship,
understand
my
this
lord, kindly, my lord, adjourn for a week.
one. Let us see that other said not here. Next.
My lord,
next matter.
no,
Next matter, please,
my
pass
lord,
it over once.
state respondent, my lord, now the panel has
Item
changed, my
number
lord.
10.
Lordship kindly give us liberty, my lord, to service of fresh, my lord, because the earlier lawyer has, my lord, not in the panel.
Samanto. Accept.
Then, my lord, I will serve, my lord, courts of the day, my lord.
Item number,
9.
Oh, 9. Item number 9.
you are for?
I'm for the appellant.
No, but respondent has to be there. Just,
But-
have you not served the respondent?
Yes, Mr. Bari is appearing. Mr. Bari is
Item
appearing for
number
the
9.
private respondent. Lead
Item number
petition.
9.
Item number 9.
Okay, now. The state respondents are not represented. It is
13, 14, 15 and 16.
Very well. Other side is not, other side you are here.
My lord, I have served the
Very
read
well,
petitioner
just- yes.
respondent.
Yes, call the list, call the list,
16 অবধি করে দাও।
call the list.
Item 17, 18, 19, 19 and 20, 21,
So far as Lordship, item 21 is concerned, Lordship. Lordship, I'm appearing on behalf of the respondent number 3, Lordship, led by Mr. Ranjoy De.
Pass it over, yes.
22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33,
I am appearing on behalf of the appellant.
34, 35, 36, 37, 38,
I'm attending this matter on behalf of the respondent.
Yes,
39 to 42.
well, make a second call.
Second call, item number 3.
He was okay. Yes,
This is my service. I have served all the respondents. And return is here. Matter, my lord. The currently application is relates to dismiss for default. I filed the restoration application. On 21st January 2020, it was dismissed. Adhan. And one unfortunate thing has happened, my lord, the private respondent, respondent number 1 is no more in the world.
please for the state.
Somnath Namaskar, hello.
Mr. Somnath Noskor represented the state respondents, led by London Senior Counsel Tapan Mukherjee.
Dismissed for default on January 2020
My lord,
and you filed this application in August 2023. It was
Delay.
dismissed on January 2020
my lord.
and you filed this application for restoration on 17th of August 2023.
No, my lord, 3rd March 2020. Or may I place the original receipt, my lord?
Have a look at it.
It is can 6, my lord.
Yes,
It is delay, my lord.
yes.
Section
And
5
the
application.
restoration is, this is the
Restoration on
17th of August. Huh? এটা কি?
on last occasion, my lord, one restoration application was restored, moved, and that was the order passed on last of that was restored. দিলে কতদিনে আছে? এই তো কথা ডিলেটা কত দিন my humble request, if your lordship kindly restore the matter, my lord.
The difficulty is this, if
My
if
lord.
you do not pursue the appeal, it was dismissed twice.
My lord. My
So
lord.
if it is dismissed twice, then why should we restore it? It was dismissed twice.
It's true, my lord. It is
Then-
my, it is,
And then in 2000, it's a matter of 2004. In all possibilities, this has become infructuous now.
it's my fault, my
No,
lord.
it has become infructuous now. Panel of 1992, year in 2020 to 2024. It has become infructuous now.
My lord, I was appointed.
You may have been appointed. For 20 years, nothing has happened.
Kindly bear me, my lord.
Sorry.
Kindly, my lord,
Stay down.
kindly bear.
Stay down, stay down.
Kindly bear me for a
We
minute.
have heard the land
Kindly
council for the
bear me.
appellant along with the restoration application. It appears that the appeal is
Kindly-
arising out of
Kindly cease the
refund. Well,
refund. And my lord, it was not my fault. Because my lord, as per the direction of the honorable court, the authority,
is there any stay? There was no stay.
no, stay,
Then
no stay. It is true.
you
my lord,
you have not enjoyed stay for 20 years. You have not enjoyed stay for 20 years. Then
I am seeking some sympathy, my lord. A
no,
person-
sympathy, what do you mean by sympathy? 2004, not even. What do you mean by sympathy? We don't understand.
Sympathy on the ground that my lord, without my fault. Actually, the
It was dismissed twice.
Yes, my lord.
So,
That responsibility taking on my upon shoulder.
no, you may take your shoulder, we may not condone it.
Alright, your lordship,
For
knows
20 years,
very well that
for 20 years,
due to-
no,
due
for
to
20
negligence
years,
of an advocate, litigant
not,
cannot.
not necessarily. The section
And my
5.
lord, kindly allow me to place the matter, my lord. My lord, kindly. Take table to come, my lord, para 80, page 83. The direction of this honorable court.
What is the other appeal of FMAT 240-2493?
That is still pending and
the Honorable Division Bench state one part of that order, but the remaining part, the remaining part was of that order with the direction to the district inspector of school and other respondents to prepare the panel and give the appointment not in respect of teaching staff only, non-teaching staff also. My lord, that is page 58. My lord, kindly take over to come page 58. Out of that order, appeal was preferred. It was passed by Honorable Justice N.K. Mitra, as the lordship then was. Page 59, my lord. Now I am placing the relevant part, if your lordship allows me.
Have you served the state
My
respondents?
lord. And last occasion they appeared.
Have you served the state
My
respondents?
lord, I served and last occasion they appeared. Today is a returnable date, my lord. On last occasion, my lord was pleased to fix the matter on today.
Why no one is appearing? I don't know. The state respondents are not represented on the last occasion. Dismissed now. You see the conduct from 2008. Now from 2008, see the
I am
conduct.
not escaping from that part.
No, if you are not escaping, then you must suffer the consequence.
That is why I am.
If you cannot escape the,
No, my
you
lord,
have, you
I
cannot
beg
escape the
sympathy
consequence.
your lordship.
From 2004, you are not pursuing the appeal. There is no stay. You will not refund. You will not comply with the order.
My lord, actually it is changed this, my lord.
I'll put that on. Right down. Uh, the the appeal service filed on behalf of the appellant shows that
I have just received this instruction. my lord.
দেখো আমাদের যোগাযোগ নেই, ও করেছে তপতিকার বাহাদুর আছে, আমাদেরকে যোগাযোগ করে না তোমার সাথে। না তোমার ডিআই থেকে করেছে।
School.
ছেড়ে দাও তাহলে আর কি। ও যদি হ্যাঁ হ্যাঁ, করে দেবো। লিগালি আসলে যদি পার্টি হয় তো হবে। কবে মারে তপতি?
9-23
No, you see, the legal heirs have a right, no doubt, because the refund is already there. Now, we may not agree with the refunding part of it, because he was not responsible for it.
Yes.
So if he is not responsible for it, then there cannot be any refund.
Then my lord, we have not received any instruction from the school.
But
School,
have you received any refund?
we do not nothing, my lord. It 2006 matter. The head of the institution informed me that appellant is no more.
No. it
Column number
says that-
5, my lord.
That requires a correction, because if he is not responsible for the mistake, then you
Yes,
cannot refund it, then you cannot claim refund.
yes.
To that extent, the order cannot be sustained. And the legal heirs,
না ওই তো বললাম না তোমাকে, ওই জন্য দিয়েছিলাম। Recovery was not permissible at any point of time, started from Shambhavu Verma. প্রভাত কোথায় গেল প্রভাত?
but why you have challenged this, prefer this appeal? It is in
Because,
your favor.
no, because of the fact, my lord, the incremental.
No, I according disposal petition ordering that all benefits to which the petitioner became entitled, consequent upon his
But so far recovery is concerned, nothing has been
takedown.
mentioned.
The writ petitioner
রাবিয়া
It is pending, I think. Pending.
Copy, copy.
রাবিয়া আছে তোমার কাছে না?
Lord, copy was not served upon me.
Yeah, that's Stay down.
Well, one thing it can be disposed of. I filed an application against the prayer, refusal of the prayer for interim order. The show the writ petition is pending. Your lordship delegate the matter because let it be heard.
Also down.
Your lordship kindly have a look to this. Order passed on 16/3/2010. না দেখেন হ্যাঁ কপি তোমাকে দিয়ে দেব। দেখো 10 still pending too.
Writ petition is
Is
pending.
still pending. Your lordship kindly,
No, where is the impugned order?
the last page 54 of this application.
No, but the interim order was vacated.
No, the order passed by
Yes, the
the,
interim order was vacated 18th February 2008.
no, this is the 16th March 2010 against
No, 18th February 2008. Item number
কোনটা
Rabia
দিয়েছে?
Khatun.
Rabia Khatun, huh?
Rabia Khatun.
Rabia Mundal.
Yes, the
Rabia
interim
Mundal.
order was vacated.
Rabia Mundal.
Yes,
No, order dated 16/3/2010.
no, Rabia Khatun.
Rabia Mundal.
Item number
তাই তো
5.
535
Rabia Khatun.
ম্যাট 540 না তাহলে
No,
কোনটা
it's MAT 208. MAT 208.
যত গন্ডগোল
Yes, Ms. Shamant. Yes, time was taken on your ground in this matter. Last time.
কি বলছো তাহলে?
Someone has taken.
রাবিয়া মন্ডল মেমো নাম্বারটা আলাদা হয়ে যাচ্ছে।
Rabia Khatun.
ম্যাট নাম্বারটা আলাদা আছে।
Rabia Khatun.
The writ petition was dismissed.
কি বলবো?
Take down.
আচ্ছা
আমার কাছেও
post which has fallen vacant in the concerned school, and if he is otherwise eligible. This leave is already given.
No, that is there, but the prayer was rejected.
No, you see the prayer. Ultimately, you won.
No, my
Liberty
lord,
is, however, given to the petitioner to apply for the post which has fallen vacant in the concerned school, and if he is otherwise eligible as per rule, then
No,
he
that is there. Your lordships kindly have a look, page 52, internal page 2 of the judgment. Concluding last portion. There is no dispute that the petition was given an appointment to the post of assistant teacher in the school in the year of 1996.
Now, this absorption cannot be made after the official liquidator in Dayanand.
No, that is the regular recruitment rules. The DA getting schools, my lord, that completely different. It is a DA getting schools. Your lordship is right if it is a recognized non-government sponsored institution.
No, but in a DA getting school, which guideline applies?
Well, there is the own circular. I did not collect that circular, but well, it entirely
what
it has
you
been
say.
discussed.
Ms. Shamantu.
2007, my lord, petitioner is.
No, but here the reference was made to Uma Devi.
Yeah, Uma Devi is not applicable. Uma Devi that requires backdoor entry if it is a backdoor. But the DA getting schools, there is a provisions. Appointment should be made, and accordingly, the vacancy whenever it will be created will be the.
Yes.
In 90, it is admitted position 1996 is working. Well, that has been.
Kindly pardon me, I have just received the instruction, my lord.
Take instruction.
My lord, I have received, but my lord, from that instruction, my lord, it appears that my lord.
Instruction
2007, my lord, the petitioner is working.
চাইছেন instructionটা দিয়ে দাও কি বলছো
You have another copy, please.
Yes, 2 copies I have given.
দেখতে পারবো
দেখুন এই তো 2007 থেকেও কাজ করছে কাগজটাও দিয়ে দিয়েছে
created after due to retirement. After that,
yes, you got the job. You got the job. Take down.
আমাদের কাছে কোনো খবর দেয়
You have heard কাগজটা দাও।
বল দাও।
আপনি কার?
হয়েছে কিছু?
Yes, Mr. Bari, are you appearing?
Yes, yes.
Yes. Who is for the appellant?
My lord, I am for the appellant.
My lord, I am appearing on behalf of state, my lord. It is
Mr. Sahara was the writ petitioner before the single bench. বলবে কিছু?
2010. একটা instruction আমি পাইনি, তবে একটা হোয়াটসঅ্যাপ একটা পাঠিয়েছে অ্যাপ্রুভাল লেটার।
14 নয়? 14 নয়? কত? My lord, 14th September 2012, the division bench passed an order. 14th September 2012.
Status quo as on date with regard to the approval of the panel and joining of the candidate to the post in question.
Now, what has happened, my
Now,
lord?
now, you
My
must
lord,
assist us.
my lord, it is a matter for Coach Bihar District Inspector. I have talked yesterday night also in the morning. My lord, from 2012, my lord, the petitioner is working. Approval
Writ
letter.
petitioner
Yes, my lord.
from
In compliance
2012.
with the honorable single bench order, my lord.
My lord, that single bench passed a mandatory order for approval of the panel. Whether the panel was cancelled, I
No.
initial I participated in the selection process, and second, without the permission of the DI, hold the interview, give that.
No,
My lord,
date is 17th of August or 10th of August. That is a dispute.
No. Question is,
My lord,
that
approval was
I tell you.
given 11th March 2013. The district inspector of schools sent the letter of approval.
An application for it also.
No, that means, no. That is approval so far as Mr. Shahara's candidature is
Yes,
concerned.
yes,
We are not on that.
Yes.
Question is this, the reason for which Mr. Shahara's writ petition was allowed was that the district inspector of schools recorded an interview was held on 17th of August 2008 instead of 10th August 2008.
My lord, the order of the division bench was passed on 14th September 2012. How the approval can be given in 2013?
Post approval.
How can it be? Whatever matter.
How can you give an approval, madam?
I have no briefs, my today.
I give opportunity to Mr. Bhattacharya to take different instruction.
Approval, whatever status quo as on 14th September 2012.
Approval of appointment.
14th September 2012.
Qualification, name, status.
Approval কি করে 13 দেবে?
কোথায়? না তো হিতেন্দ্র, yes. এটা দেয়া যাবে? 11/3/13, 11th
You
March.
file a report
Yes.
disclosing all the documents. And what you have to say on the merits? Is the state opposing or because you have to support your own finding?
Yes, my lord.
The DI passed an order disapproving the
Because of the date of
no, not date. Initial permission was given and my lord, that was postponed. If that is postponed, rule says you have to take a further permissions from the DI.
Correct.
Without taking that permissions,
My lord,
he will hold an interview and selected his own.
petitioner is a group D staff, my lord. Kitendranath, my lord Bormon. My lord, I have only received the letter of approval.
No. You file it because the school did not produce a relevant record. The DI did not produce a relevant record. That is why the order was passed. You did not produce a relevant record. So you must file an affidavit disclosing all record relating to this matter in the form of a report. And we shall, because the report will speak for itself.
My lord, give some more time. It is from Coach Bihar, my lord.
I have lost my briefs, my lord. I
No,
shall
I will
take
teach you.
Commissioner Bhatt.
No.
I'll supply.
Neither of you are required to be heard. It will the record will
Yes,
speak for
yes.
itself.
At least, my lord,
It will be upon Ms. Samanta to.
No, I will hand over. I will hand over to Mr. Sir.
My client
We
has
have heard the
already
land
retired from
council.
service.
We have
তাহলে এখন retired
The
করুন।
land council for the, we have heard the land council for the
No.
parties.
তোমার
We direct the district municipal schools. District municipal schools.
Kuchbihar,
Yes, yes,
Kuchbihar, my lord.
Huh?
Kuchbihar,
কোচবিহার
Secondary.
To
secondary
file
election,
a
Kuchbihar.
report in the form of an affidavit disclosing all relevant documents pertaining to the issue, including
না ঠিক আছে জেরক্স করে।
including approval, if any, in favor of the writ petitioner,
Petition.
along with the approval memo within 2 weeks.
My lord, some more time.
Why you burden the court with,
They have not,
with unnecessary papers?
they have not annexed our petition.
Doesn't require.
Copies of.
Why you burden the
তোমার
court with
petition,
unnecessary
right,
documents?
Matter to appear after 3 weeks.
We'll see to the record and pass the order. Well, next.
So copy.
Item number 10,
Yes, my lord.
10 my lord, I appear.
Yes,
বুঝে এনেছো? ওইটা শামসুল হতে লাগবে না। এটা
10 কি হলো, 9 টা কি হলো?
date of death, the rules.
আমি কি দিয়েছি order? ও আচ্ছা, দিয়েছি। Yes.
হ্যাঁ,
Yes,
rules
Mr.
my lord,
Samanta.
it is, হ্যাঁ, এটা কপি দেওয়া হয়েছে। কি কি রে?
Yes.
Let me check up, my lord. My learned friend says that the no copy has been served. Copy দিয়েছো?
না না দেয়নি
দেখো তোমার আছে।
নেই কপি নেই।
আগের দিন অ্যাপিয়ার করেছিল বলছে।
সে হয়তো কোর্টে ছিলাম আমি কপি পাইনি।
তাহলে একটা চিঠি রাখো না কেন? I'm serving copy in course of the day.
But there is no scope for an interim order.
No, your lordship can dispose of the matter. That is a settled law. The law prevailing at the time of death will apply. Now my কি বলো তুমি?
পাইনি কপি নেই আমার কাছে।
দিয়েছে তোমার কপি, দরকার হয় একটা নিয়ে নাও, কোনো প্রবলেম নেই। কপি দিয়েছে, তুমি নিয়েছো। Now the question is, my lord, whether the compassionate appointment would be considered in terms of the earlier rule or in terms of the rule, my lord, which has been which came into force long after the death. To show, my lord, the prayer was rejected on the basis of the computing benefit of the retiral dues. That is not sustainable in law in view of the judgment of
No.
Captain of the
That is
decision.
sustainable.
No, my lord, because 2007, if your lordships kindly have a look to this,
That is sustainable.
your lordships kindly,
It is sustainable.
yes, your lordships kindly. এটা কপি আছে তো? কপি তোমার হারিয়ে গেলে নিয়ে নেবে একটা কপি।
If you are relying upon Gobind Prakash,
No, Gobind Prakash gone.
then
I'm not.
then-
I'm relying very current judgment of 2022 two Supreme Court cases, page 157.
yes,
Gobind Prakash, I'm not.
কুমার খান
একটা ফটো
yes, that's true.
to show. But there was the circular didn't see the light of the day on that when the death occurred.
But there is a contrary judgment.
No, after 22, my lord, I believe, I do not know. I shall
Prior
check up.
to there is a contrary judgment.
Prior, but 22, our division bench has held.
Now, that also I have held, but that's not the issue, but.
Now your lordship kindly see the
You
impure
have
order.
a contrary judgment as well. That's what I'm saying.
Now, your lordship, can you see the impugn order?
Yes, you take instruction, consider this judgment, come back.
Yes.
Yes, when? Day after tomorrow.
Day after tomorrow.
For orders.
My lord, for
South
getting
24 was
instruction.
South 24 was.
Refers,
1 week, next week, my lord, I have to take instruction. South 24.
Anyhow,
নোটিশটা দিন
Next week.
নোটিশটা দাও তুমি।
আমাকে দিন আমি জেরক্স করি এনে।
কোনটা? আমি দিয়ে দিচ্ছি,
Copy
তুমি
টা?
নোটিশটা দাও, আমি আবার কপি দিয়ে দিচ্ছি। না, কপি নিয়ে আমার কাছে কপি নেই, দিয়ে দিও তুমি।
অনেকগুলো আছে।
অনেক বড় কপি, কতগুলো ওয়ার্ড। দেখো ওটা কি? ওটা দিয়ে দাও।
দেখে দিচ্ছি এটা।
মেমো পেপে মেমো লাগবে না। সব নিয়ে নাও। দিয়ে আমাকে পাঠিয়ে দেবেন, আমি করে দেবো তোমাকে। কে পয়সা দেবে তুমি? আমাকে তো কপি নেই কিন্তু।
পেয়ে যাবেন নিশ্চিন্ত।
দেখে দাও।
South
you have a judgment in your favor is 2020 volume 2 SSC that is followed. You have a contrary judgment that is 2021 SC 5620.
2020
AIR 2021 SC 5620.
5620
2021
হ্যাঁ
কত?
এআইআর 2021 5620
56.
No, but if there is no other delay and other things, then you please consider it. Because we have also passed an order saying on the date of the death. It has to be considered. Is there
Now,
any
my
problem?
lord, the poverty is not denied. It is only the retirement dues you cannot ask. If I have other source of income, the question would have been otherwise. Penury is
We
there.
have heard the land counsel for the parties. Mr. Bari has relied upon the decision of the Honorable Supreme Court in such and such and such and such. To argue that Imtiaz Uddin was appearing for the appellant.
Well, let it be next week. Your briefs are not traceable. That's why one of the problem on the old matter, sir.
So who is representing the state? Does anything
Oh.
survive?
Your lordship can leave. দেবে তো লিস্টে নাম তো দেবে আছে মানোটা কিছু আর
This is covered by PRE Shah's judgment. Take down.
মানে would your lordship not allow us to let us next week along with this matter we can try our level best or dismiss for default. Your lordships can
But the name of the advocate on record has to be changed. If you file a power.
I will file.
What's
Vokalat নাম।
এখানে কাজ করবে consequent upon a fresh power being filed, consequent upon a fresh wakalatnama being filed by Ms. Shamanto, the name of the advocate on record printed in the cause list shall be changed.
My lord, may I be permitted to one humble prayer? In item number 5, my lord, may I kindly permitted me to get a copy of this department from one Xerox copy, my lord.
Of what?
Item number 5, we both do not have any copy.
Which one?
Disposed of, but we do not have any copy. Mr. Badi has also do not
What
copy.
copy?
Well, memo of appeal or either or.
You can always apply for certified copy. No leave is required. You apply for.
Item 13.
এটা দিয়ে দিন।
Yes. Yes. Who is your other side?
My lord, it served earlier, my lord.
No, but John Tomitra is for the council, but if he is not appearing, then
Now he is not in a council, my lord. Now Mr. Bosho is appearing for the council, my lord.
take down. Since the council is not represented, let a copy of the memorandum of appeal and stay petition be served on Mr. Bushu. In 1 week from date, the matter stands adjourned for a fortnight.
Not this week,
Next,
not this.
next,
14.
My lord,
14, 15, 16 are the same.
my lord, no, 15 and 16. My lord, there is an order of the there is, my lord, there is an order of the Hon'ble Court. 3 matters will be heard together. And but my lord, respectfully submit the 3 matters are not similar. This is my change brief. My lord, I have gone through the record and came to know that 605 and 606 are not similar in this matter. What happened, who appeared on behalf of the petitioner respondent, he wrote a letter to the college that 604, 605 are similar matter, etc. That's why this complication arise. Subsequently, we faced a contempt in another matter, which has been filed by the writ petitioner and obtained an order. In the said writ petition, we faced a contempt. Thereafter, my lord, I have been allotted this brief and I made a thorough search and came to know that 605 and 606 are not related with 604. But in 604,
No,
I
5
find
and 6 are related.
604.
No, 5 and 6 are related.
Lordship, 604, there is a, for the writ petition, Lordship, that matter, Lordship, I'm.
604, 605 and 606 are not similar.
Not similar.
604 and 5 are similar matter, Lordship. Factors different,
No.
but the petition
No,
is
no.
same.
Lordship kindly see 605 is another matter, though it has been written governing body. Kindly Lordship overleap the
One matter,
cover, then Lordship came to know that that is another matter. That creates complication. That's why, my lord, this matter was faced contempt, etc. And in the contempt application, we saw the
No, is there any order that all these 3 matters to be heard analogous?
yes, there is an order of this
that
Hon'ble
FM
Court.
604 is that person who,
But-
that matter,
But respectfully
the honorable
submit that.
single judge regularized that matter, Lordship.
But
They
respect.
challenge that order against that
But
order, Lordship.
respectfully submit, my lord,
I
that
see,
are
sir.
not similar matter. Lordship kindly go through the file, then Lordship will.
No, no, দেখি অর্ডারটা কোথায় অ্যানালগাস হিয়ারিং এর কি অর্ডার আছে দেখি
In the order sheet, it has been written that 3 matters are similar,
There is
so
order.
it will be heard together.
No, it must have been submitted by someone.
Someone submitted.
Yes, so
Yes, someone submitted.
এটা দিয়ে দেন। নিশ্চয় চলছে।
কত চলছে 18?
There is an order on 9th February 2015 where FMA 604 is required to be heard with MAT 1277. MAT 1277 must have been renumbered now. এই MAT 127 এদিকে অন্য ম্যাটার গুলো তোলো তো অন্য ম্যাটার গুলো তোলো
1277.
This 1277,
কত FMA কত আছে এটা হ্যাঁ 605 তো 604 and 605
no, 1277 are not this matter.
605.
no but in terms of the order of 9th February 2015 FMA 6054 is required to be heard along with FMA 605.
Lordship,
Yes.
Lordship.
But lordships kindly see, that is different matter. Kindly see the paper book.
Lordship, matter are different, but the one matter there.
No, that is full matter.
No, the issues are same.
Issue are different because.
Then issues are different, then has to be heard separately.
But
All the
Lordship,
three matters have to be heard separately.
Lordship,
Now, who is for, you are for the,
respondent, they have
no,
to apply.
you are for,
I am for the appellant, they are the writ petitioner respondent. And in this matter, I have filed a restoration application,
no, no.
because my lord, that has been dismissed.
Where the question matter has been heard, also they didn't appear. I'm suffering since 2018.
No, governing body of Kandiraj College, you are representing.
I am representing, but lordships kindly see the president had died.
Aparna Rai Sengupta, who is representing Aparna Rai Sengupta.
Lordship,
Who is representing Aparna Rai Sengupta.
No,
no.
that is the complication.
The other appellant is Aparna Rai Sengupta, who is appearing for her. And another is Mir Zamal Ali.
No.
Who is representing for them.
Maybe there is some cost.
This is, lordships kindly hear me, this is different.
No, then we detag it, there is no problem, but we detag this, there is no problem, but
And my lord, in the 604, when the president had died, who filed this appeal, appellant number 2 had died, Vikas Shina. 1 month ago died, my lord, is a scientist. But the teacher in charge has been substituted, and now my lord, principal is there, I am representing principal.
you are representing Indrajit Das.
Lordship. I have a
Indrajit
paper book
Das
where
is
this
also
FMA
related-
605, there is also governing body where it says Indrajit
No,
Das.
that is wrong. The
Construction
cover
body-
is wrong. The cover is wrong.
You should check the file.
How the service could be regularized? On
Lordship,
what basis? On what basis you are appointed as a casual employee? How it can be regularized? On what basis?
Lordship, at the same time, they are regularized of that
That's a
different
different
person.
issue, madam. On what basis this service can be regularized? In 2012, after this official liquidator Dayanand's judgment has come. How?
Not only that, in the year 2012,
Please tell us.
he is not working.
How?
Lordship, I'm pretty much short pass over. Lordship. In this matter, Mr. Bhattacharya will appear in this
Who?
matter. Mr. Bhattacharya, Vikas Ranjan Bhattacharya.
Yes, where is he? How he can be regularized? On what basis?
And suppressing a fact that his service has already been terminated in the year 2008, obtained order in the year
But
2012.
that for the school authorities or others to appear. That fact was not brought,
No, that fact has not been stated.
but his name was recommended for approval before the director's public instruction.
No, not his name
That's-
has been recommended. Not his name has been,
No,
He
that
has
is
been-
what the order says.
yes, madam, that has been
Is there
said,
any record showing that?
Also annexed,
because the governing body did not appear on that day.
No, you have
And that
annexed the
creates
approval.
complication.
Lordship. Page 57, there is an order.
Page 57.
Lordship. Page 57, another person at the same time, their approval for for his regularized lordship. But
that is the post of clerk.
but
No,
they
but he
initially
was-
appointed as a
No,
political.
but he was entitled to participate with his qualification for the Group C post.
Group D.
Group C,
He was working as peon. And 2008, my lord, his service has
so
been
he
terminated.
was not entitled to participate in the Group C post.
My lord, no, my lord, and my lord, his service has been terminated in the year 2008. And he obtained order in the year 2012. He has not worked there for 10 years also.
After termination.
That is our
lordship,
case,
I
my
filed-
lord.
On that time, I filed a writ petition and that
Another
termination,
writ
has
petition.
been-
No, but
that termination letter has been set aside before the single bench lordship. And they prefer an appeal
And
against that order
thereafter,
also.
and we obtained stay.
That is 605, FMA 605. I
No,
have a-
no, that is not 605. That FMA number has not yet been given. That is, my lord, mat number 177, 1777 of 2014.
no, but is there any stay of operation of the order of 26 September 2012?
My lord,
Is this order has been stayed 26
yes,
September?
yes, previously it has been
2014.
stayed. Subsequently, it has been dismissed for default. This order has been stayed.
There is no stay. Where is the stay?
There is,
Lordship,
there is,
No, when
Direct
the
to
order of
Sapa
stay
copy.
was, when the order of stay
Even
was
it didn't
granted.
appear, several.
order
petitions-
order of stay, we have obtained, my lord, direction of paper book and so on 9th February 2015. Direction of paper book and stay.
No, there is no stay, only paper book.
There is no, we do not find any order of stay.
My lord,
There is no stay.
kindly,
lordship.
yes, yes, there is a stay.
Show me
I'm
the
February,
copy.
just
My lord, on 4/12/2013, delay,
The same thing.
Just a minute.
the delay has
Yes,
been,
yes, yes.
there is a
The
stay,
order shall remain stayed till the disposal of the appeal.
my lord. And thereafter, the matter was dismissed on 9th July 2019. And my lord, in time, my lord, we filed restoration application.
But if you are appointed as a temporary staff, how the regularization absorption can be made? First of all, the state may have, if they framed a policy, your case may be considered in terms of the policy.
Lordship.
If you are not, you have no right in terms of the official liquidator and Dayanand's judgment.
Lordship, in the year 2001, I was appointed as a clerk, as
As a
PO,
casual employee,
casual, lordship.
then how the regularization can be done? On what basis?
And 2008 terminated
On what basis,
due
madam?
to beaten to another employee and also insulted to the
Just
professor.
tell us, on what basis? What law?
Lordship, after 2006.
Just
Umar-
because someone has put in service for 5 years, his case has to be considered and appointment has to be given.
No, Lordship.
Then
But after.
how you sustain this order, madam? How you sustain?
Lordship, can you have a look, page 41? There's a principal Kandiraj stated that the clerical certified that is Sri Indrajit Das, who is a casual staff, work in the college library since 2001. With entire satisfaction of the authority, his nature work of the library was clerical nature. In the year 2006,
So his name was sent for consideration for approval.
Lordship.
Now, if either there has to be, Umadevi she said that if a person is doing for a say 10 years,
10
6 years, 7 years continuous, then state may consider, I think, that there are 1, 2, 3, maybe 3 is there, which says that if it is not irregular, if it is not illegal and maybe irregular, the state may formulate a scheme for the purpose of absorption. So the state is the best authority. In absence of any scheme, how your service can be regularized?
And his service has not been sent for approval.
So
This
that
is not correct.
So that is, he is saying his services.
But that is not correct. In the year
Please, Governor,
2008, my lord,
only
terminated.
Short pass over, Lordship, and make it not today, I'll submit tomorrow on this point
Why
only.
you are not ready?
This is also changed, Brave Lordship.
What are the applications?
My lord, restoration application 7778. Another two application has been disposed of. Section 5.
7778
একটাই আছে একটাই আছে
Take down.
Paragraph 3.
This is an application for restoration. This,
First time.
no,
Second,
That may be, my lord, that I don't.
you have to pay costs.
No, my lord, lordships kindly see,
Absolutely. What
Well,
no?
kindly see the ground and time in,
Doesn't matter.
my lord, in time I have
You cannot, you see, if you see the orders, if you see the orders, most of the time the appellants are not represented, most of the times.
maybe, my
Then-
lord. But lordships kindly see, it's a change brief.
Maybe.
And lordships
The council-
2019,
council
my lord,
must-
COVID is,
council must pay
my lord, thereafter,
from
my
their own pocket.
lord, COVID is continuing. Lordships kindly see,
Take down.
today I'm just first appearing, my lord, by change
May
brief.
be first appearing, council must pay this.
15
answering this lordship's query.
May I
Nehal
submit only
Singh
one?
says, create a post and appoint.
No, exceptional circumstances. Is absolutely superannuary post is an exceptional, extremely rare cases, not as a matter of right.
No, sir, they are subject to lordship's
Not as a
correction.
matter of right.
Subject to lordship's correction.
Absolutely.
Like,
Superannuary post is not as a matter of right.
no, their Supreme Court says the Uma Devi cannot be a license for the state to exploit somebody. And that the issue was decided by the Supreme Court on the point that every human being, every citizen of our country has right to lead a dignified life.
Absolutely. No,
And
no
that's the
problem.
point. And after
problem.
considering,
So if you by manipulation, if you know someone, get an entry into the job without any sanction post, and then you'll be regularized.
if it's required,
It's a different. Don't go by those prophetic words.
May I submit? Let the
Sometimes these words are empty.
let this matter also filed by governing body within another order.
They are not required.
Yes, that is also here. I mentioned this matter. Let this matter be appeared along with this matter. MAT 177.
can I take it up tomorrow? I'll come with those.
So we are facing it for hearing.
These matters should also.
No, but who is your other side in this matter?
But they, my learned friend.
No, I am for the writ petitioner.
Yes.
Now I'm like, kindly fix a particular, kindly do, instead of posting in my, let it be decide on the question of law. This can be decided tomorrow.
Here and now we are about to set aside the order. Your junior asked for time, that's why we are not. It's contrary to law. This shall be listed along with, this shall be heard along with the MAT here, FMA. You have not given the FMA number.
No, the FMA number has not yet been. There is no FMA number in this matter till date.
We have received a paper book, man, informal paper book, man, if I'm not.
এটা নয়, এটা correct নয়।
এটা correct নয়?
দেখো না, রেকর্ডটা দেখো না।
আছে?
আলপনা।
605?
সেটাও ভুল।
এই গানটা হবে না, একটা ভুল।
আরে বাবা কষ্ট করে বলছি, দেখে নিও না, আমি ভুল বলতে তোমাকে।
হ্যাঁ?
আর 15 and 16
পাতাটা may I serve copies to the state?
Yes, yes.
হ্যাঁ, ঠিক আছে, ঠিক আছে।
Grateful, madam.
কি অর্ডার দিল?
এটা দেন আমাকে। তাহলে আমি ছবি তুলে নিই।
ছবি তুলে ওনার হচ্ছে ওই আপনার 2 সপ্তাহ
Only one clarification I had talk with my learned friend. We have just checked them let enter file let. But there is a mistake let on the cover note on the head cover note of the let FMA 605 has been written let wrongly let. The file is correct. File is let MAT 777 of 2014 let.
Yeah, DTAC 605 and 606.
Kindly retain the file.
No, file that is a different.
Like the paper book of
File
MAT 1777 of 20.
করে দেবে সেটা তো আপনাদের কাজ ফাইলটা ঠিক করার
It will be listed along with MAT 1777 of 2014.
না না ডিট্যাগ হবে তো ফাইল কভারটা ভুল আছে বোঝার চেষ্টা করুন
Yes, top sheet টা ভুল আছে. It will be yeah, list হবে 1777 of 2014 এর সঙ্গে MAT.
সেটা অর্ডারটা দিয়ে দিয়েছে নেক্সট
17, my lord, I am for the applicant, my lord.
For the TPSC Purvo Midnapur Council, your lordship.
Yes, give us the paper.
My last occasion, your lordship directed the learned advocate of the primary council to produce the reports, my lord.
Lordship, Lanesh has not come to the court. I'm praying for not to, your lordship. He's suffering from fever, your lordship.
No, who is appearing for the council?
I'm appearing.
Former Mr. my lord.
I have been told that Mr. Mishra is suffering from fever, my lord. He could not come, my lord.
Record has not come.
No, he has not come today.
Record.
You are junior to him.
Yes.
They don't. The prayer for adjournment is made on behalf of ডাকো
18.
Yes.
Well, 18 I appear with appellant. Every service করতে বলেছেন
Who is appearing for the respondent?
My lord, pursuant to lordship's direction, we have served the copy upon the state.
I'm for the state lordship, led by Mr. Anshar Mondol. Lordship, due to his leg in fracture, he has not.
Leg injury.
Leg injury, I'm
আসছে না তো।
lordship praying for not this week, lordship.
He will come next week.
Lordship.
না আসতে পারবে নেক্সট উইকে না 2 সপ্তাহ করো কি এক
Better,
সপ্তাহ
2 weeks অনেকটা better আছে তো।
সেটা দেখো
সেটাও 2 সপ্তাহ। A prayer for adjournment is made on.
It is better adjourn for fortnight.
The matter stands adjourned for.
Copy this one.
19.
Yes.
19.
19 years.
Madam, for the respondent in this matter. It's an appeal filed by the state, my lord. On the last occasion, your lordship was pleased to direct them to file a report.
ও আচ্ছা তোমার এটা 2 সপ্তাহ কত হলো 18 দিন আগেটা তো হ্যাঁ 2 সপ্তাহই তো করতে হবে
The appellants are not.
one IPF for the appellant. That this is an application for restoration. That pursuant to your lordship's direction, but I have served the respondents. Well, this is my affidavit of service.
ওই আগেরটাই যে বোধহয় কৃষ্ণের সাথে নামটা নোট করে
But it was the desire of your lordship that the main matter will be taken up by your lordship with the restoration application. হ্যাঁ এই বইটাতে আমাদের
The application for stay was dismissed for default.
yes.
But that was restored. That oh no, it's a subsequent restoration. Yes, what you say?
So far as restoration of application, I said
Sufficient cause being shown for no. Yes, but it has not been recognized by the state of West Bengal.
Yes, that is the case, but I have to,
See, if there is a body, expert body deciding on this, court will not enter into this.
court has entertained, court passed the order. The Commissioner of School Education and the Principal Secretary of the Government of West Bengal, they have complied with the order. But I want to place Justice, just a second.
No.
Ojonath Ray's judgment for a minute and the complaints. But if your lordship clearly turns to page 70.
Your writ petition was dismissed.
Yes, absolutely.
So it was not recognized, but the government has taken a stand. Government said that it is not
At
recognized.
page 69, our stand is clear.
But may I place the order of the this honorable court and the compliance?
Forget about the compliance. Compliance or the threat of contempt is no compliance.
No, not on the threat of contempt. Kindly have a look to page 70 once, but in a different case.
Yeah, we are no. Please don't go to a different case. We are on a particular case. So question is this: whether the degree obtained by her from the Himachal Pradesh University by virtue of correspondence course is not recognized
The High Court
by the government of West Bengal.
But the GO, the government order of which kindly turns to page 74 once. Kindly turns to page 74 once. It is from the Secretary of School Education Department to the Director of School Education. It was done in 12th of May 1999.
The expert body, they have to decide on equivalence.
But the Secretary is the highest body. The Secretary, page 74.
Yes, but secretary has, what the secretary has said.
Secretary has said, in compliance of the order dated so passed by the Honorable High Court in the aforesaid matter, the undersigned is directed by the order of the governor to say that the geo number so since quashed by the High Court, may be directed as non-existent, and to say that the benefit of pay and allowance may be granted to the petitioner accordingly as ordered by the Honorable Court, and to request him to communicate the memo to the DI in favor of the taking necessary action from their end. This is absolutely regarding the degree of Himachal Pradesh University. That is the judgment of Justice Ajaynath Rai in 1996, page 70. Then page 73. In connection with the above subject indicated above, the undersigned has to request him to take immediate step to comply with the order of Justice A.N. Roy dated so in the aforesaid matter for granting benefit of higher scale of pay to the petitioners for obtaining PG, that means postgraduate degree, through correspondence course conducted by the Himachal Pradesh University. Well, this has been ordered by the Director of School Education, West Bengal, in 1997. And it has been sent to all the DIs. DI North 25 Parganas, DI South 25 Parganas, DI Kolkata, Hooghly, Howrah, and Barrackpur. The government has complied with. Then the secretary said, well, he is the highest body. Page 74. Well, kindly receive the division bench order, page 130. It is reported in 2002 to CHN. Starting from page 111, Justice Ashok Kumar Ganguly and Justice Pranab Kumar Chattopadhyay's judgment. Page 130, paragraph 56. This court, however, directs that, but it is at 130. বসুন এখন বসুন বসুন আমি দাঁড়িয়ে আছি বসুন
Now, your case was not allowed.
My lord,
The approval was not given. The approval was not given on 25th July 2000.
that my approval of first given, so page 78.
Provisional.
Huh?
Provisional.
Millet, my approval was given page 78. Can I have a look? Millet? 78. 23rd of February 99. Approval of the panel.
No, we are not on the panel. Question is this, that
It
on
was
23rd February 99,
Huh?
your certificate was accepted.
Huh?
Your certificate was accepted.
Hmm.
It was accepted. Is it accepted in view of the setting aside of the notification of 12th May 1999?
Let the order just now I have shown to your lordship. Page 73. Mm. 73 and 74.
No, but what is the government order of 19th December 1994
19th December 1994.
on which you are placing reliance? Because you are saying that because of 1994 you are eligible. That is
Hmm.
your case?
Just a second. Well, kindly give me 1 second. Time.
Is it your case that you are governed by the 1994 by reason of the setting aside of set aside
Yes.
quashing of
Yes.
1994? So you have become, so what is the
Absolutely.
1994 circular?
Well, give me 1 minute time. Now to the problem.
Does 1994 mention about anything about Himachal Pradesh University?
Daro.
Or it only specifies few universities?
Daro. এটা বেশ আপনাদের পাবেন। এটা হচ্ছে এইটাতে বাড়িতে আপনার কাছে 2 আছে? 2টা আছে? হ্যাঁ? ভলিউম 2টা আছে?
ভলিউম 2টা দাও।
ভলিউম 2
ভলিউম 2 এটা ভলিউম 2।
এখন তো বলেছি পুরোনোটা তো এটা।
এর পুরনো একই 94 থাকবেই।
Yes, page.
But I don't have the volume 2 with me.
This one.
Yes, may I get your
এটা দাও, এটা
from
দাও।
এটা বইটা ওটা না ওই চর্চা বইটা দিই।
Usually 94.
হুম। দেখছি না 19 that this geo is not there. It is not in the book.
You have the geo of this?
I don't have.
দেখো তো নেটে দেখো
It's a long back. I could, then I have to take. instruction.
No. They are basing their case because of washing of 19 December 1984.
Yes, if that has been quashed, then he getting
Yes.
the right.
Because in 1999, his name was included. And by reason of the judgment in Gita Guho, it says that it is obvious that the notification dated 21st March 2000 could not be considered in all the judgments delivered prior to its issue in the case of such and such. So this, it depends upon whether 21st March 2000 would stand in the way or not on the question of equivalence. Now, if the 1994 notification only specify few universities, exclude Himachal, then he has no case.
Obviously.
Because it gives an impression that possibly the 1994 read with the 1999 circular, it only recognized Indira Gandhi National Open University, Vidyasagar University, Burdwan, other universities in the state engage in providing distance education, and Netaji Subhash Chandra Open
That is in
University.
West Bengal.
And also the certificates issued to successful candidate by National Open University, New Delhi, and Robindra Mukta Vidyalaya. If Himachal is not included, then you are not, then you cannot get it.
Actually, it recognizes certain universities. It does not.
If 1994
It
is
is
relation
inclusive
to this, then
notification.
Himachal, if it is not included.
But Himachal was included in terms of the order of the High Court. Because if your Lordship kindly turns to page 73, but it was in 1997 for the first time. Kindly have a look to page 73 once, minute. The Commissioner of School Education is writing to the DIs on 13th of March 1997, by which, in terms of the judgment of Justice Ajanath Rai in 1996, for granting benefit to the higher scale of pay of the petitioner from obtaining PhD degree
That is why
through correspondence course.
in 1994 was quashed. 94 was quashed.
Yes.
94, it does not include Himachal. Does it include, is there any circular which has included Himachal?
But kindly give me 1 second time. Before Justice Rai, yes, page 70. Kindly have a look. Before Justice Ajanath Roy, kindly have a look too. First, second, third, fourth, the last paragraph, first page. The reason why the state respondents seek to withdraw the additional pay is apparent from the departmental notification dated 19th of December 1994, just now my lord has said. By such notification, an assistant secretary to the government has been directed to state that the state government will not recognize degree obtained through correspondence course as equivalent.
See, the thing is this, you are for the state.
That judgment, that notification of 1994, that was quashed on the ground due to some technicalities, because it was signed by the assistant secretary, not by the governor. Lordship, kindly come to page
No,
6.
that is not the issue. Justice, once this notification has been washed, then the other notification is your 1999.
1999.
Now, 1999 says that in compliance with the order dated 15 January 98 passed by the Honorable High Court, the undersigned is directed by the order of the governor, such and such is since quashed. Maybe it is non-existent. So no one can be declared disqualified on the ground of 19, whatever the technical, non-technical. So when she applied for it, or rather when she thought that she's eligible, at that time, 94 circular was not there.
Was not there.
The 99 circular says that the benefit of pay and allowance may be granted to the petitioners accordingly as ordered by the High Court. Now, their case, whether it's the case of those three were there or not, we don't know.
That was
Mrs.
not-
Ojanath Rai's judgment is one of them here. The three cases on which 12th May 1999. But in any event, if that circular goes,
Ankush Ghosh.
then it cannot be given effect to. So if that circular is not there, then whether she was eligible in
No, my lord,
1999,
the question is that in 1994, it has recognized certain universities.
so that is squashed.
That is squashed.
And there is an order of
Therefore-
Justice Ojanath Rai.
All the whether there is any further, I have to take instruction whether there is any.
No, you see, the thing is very simple. In 1999, you recognize.
Yes.
You recognize because
Due to
found
judicial
this-
pronouncement. Due to the judicial pronouncement.
yes, so in his case, in her case, it was not decided. But you thought that since this was circular was set aside,
Yeah.
so she became eligible.
Absolutely.
Now, if she is eligible on that date, then there is maybe a subsequent circular of 21st March. Subsequent circular of 21st March. Now, what does the subsequent circular say of 21st March? This Himachal Pradesh degree came up for consideration before the special bench. ইস, আমাদের বেঞ্চ ছিল এই স্পেশাল বেঞ্চে অর্ডার বের করেছিল স্পেশাল বেঞ্চ আমরা চক্রবর্তী আমি আর সৌগত ভট্টাচার্য স্পেশাল বেঞ্চে জজের অর্ডারটা পেতাম আমাদের তিনজনের যে বেঞ্চটা হয়েছিল না জাস্টিস চক্রবর্তী আমি জাস্টিস চক্রবর্তী আর সৌগত ভট্টাচার্য
ও জজেবি বেঞ্চ
সেটা হিমাচল প্রদেশ ওয়াজ এ পার্ট অফ ইট না না না, আরে ওটা হয়ে গেছে হ্যাঁ ওই
This is that
you are for
I'm for the state.
yes
Lordship, kindly see page 69. Actually, after 1994 notification goes, no such notification at that point of time.
so there is no notification till 2000
In 2000, that whether, so far my instruction goes, whether all this distance education has been recognized or not. There is no specific order. On the basis of that, her regularization has been, service has been terminated. Lordship, kindly come to page 6.
service is terminated.
Yes, she was provisionally approved. After all, approval was withdrawn.
Approval for higher scale, not for terminated.
No, termination. Termination was no, not for higher scale. It's a simply there's something different issue.
No, but here it says
Lordship, kindly see page 69.
no 78. Please come to 78.
No, Justice Ojanath Rai's judgment was on a higher scale of pay.
Yes, on a higher scale.
And it is regarding to termination whether this degree is equivalent and recognized. That's why I'm on the very
68.
The very first line I uttered whether it is equivalent as per Gita Guho. First, it has to be equivalent, then it has to be recognized.
Recognition comes first, then equivalence.
So unless it is equivalent, it cannot be recognized. That's why Lordship kindly see the Gita Guho's direction.
Yeah, request. No, yes, page 68, fine, then
Page 69.
69.
Hmm.
Yes, there is 25th July 2000.
2000. After careful consideration of his proposal on the subject mentioned above, the undersigned is directed to inform him that the directorate is not in a position to accord final approval of appointment in favor of Srimati Dalia De now Dalia De Mojumdar. In absence of any specific government order, there is no such government order whether this has been recognized or not. Whether these universities are recognized or not. Once 1994 goes about the correspondence courses, there is no government order that the correspondence courses are at all recognized or not.
No, but how you are deciding the cases? For example, Justice Ojanath Ray's judgment on Himachal high scale of pay. There you accept the.
There we have.
Where is the 1994 circular? Show us the 94 circular.
That circular, my lord, I don't have.
Is
right
there?
now,
Is there?
some time may be given.
Headmaster manual, it is there.
But it is not there in the.
That's
It's
the
there.
problem
We
is
have
that
read
it's
it.
not in
We
the.
have read it.
No, no, no.
Peche.
Most probably since it has been quashed, that's why the latest edition does not contain that circular.
Paragraph 21 of the special bench judgment. In view of the above discussion and consideration of the fact that the petitioner obtained his higher qualification even prior to the issuance of the last notification pertaining to recognition dated 21st of March 2000, he cannot be denied the benefit of higher scale of pay on the basis of the master degree obtained by him in a relevant subject through correspondence course from the Himachal Pradesh University. Mere so, when the person similarly situated with the writ petitioner has been granted such benefit by the state respondents as would be explicit from the memoranda dated so 4th of November 97 and 28th of October 97 annexed at page 35 and 36 of the writ petition. And as such, it would be an idle formality to remand the writ petition to the single judge for any further hearing. Accordingly, we set aside the order dated 17 January 2002 issued by the respondent 2 and direct the respondents to grant postgraduate scale of pay to the writ petitioner along with all arrears with effect from the date of following the last order of examination held in November 99 together with the revised pensionary benefit upon fixation of sums. So, your lordship has practically allowed it. Special bench. এই তো ওটা প্রিন্ট আউট বার করলে ওর কাছে তো রয়েছে বার করেছে ও জসেফের কাছে আছে আরে না দাঁড়াও এই তো দিচ্ছি দাঁড়াও এই তো আমার কাছেই তো অনিতা বার করে দিলে প্যারাগ্রাফ 22
নাম্বারটা
21 22
নাম্বারটা দাও তো
WPA 7452 চোদ্দ কত হচ্ছে আমাকে পাঠিয়ে দাও না পাঠিয়ে দাও ঠিক আছে
Yes, that's why we said. You see the notification on 19 December 1995 4 it denied recognition to degrees obtained through correspondence course from the Himachal Pradesh University.
My lord is reading page, paragraph.
Page 5 of the judgment. Read paragraph 6.
6. It needs to be pointed out. Initially, by notification, it tends only the master degree obtained through recognized. Thereafter, a notification was issued on 19 December 94, denying recognition of degrees obtained through correspondence clause from Himachal Pradesh University. After the notification dated 19 December 94, was quashed in a case of Kalidas Gangopadhyay. But it is also annexed to this petition, Kalidas Gangopadhyay. The secretary issued a notification dated 12th May 99, directing inter alia that notification and so and so may be treated as non-existent and the benefit of pay and be granted. Well, that is also annexed here. Utpal Man, it is also annexed. Cannot be denied recognition. Therefore, thereafter, the state government has modified 21st March granting recognition to the certificates awarded by so and so universities of the state engaged in providing a correspondence course. Subsequently, commission. এই তো 6 যশব 6 পড়তে বলে তারপর 7 না তুমি এ পড়া কি অবস্থা বলো তোমার ঠিক আছে হোক না দেখা যাক কি হয় যাও শর্ট পাসও বানাও দুটোর সময় করো Paragraph 18 টা দেখো para 18 equivalence of a degree
Paragraph 21 is really what we said, that we said
yes
that
correct, I've read in view of the
in view of
discussion
the above discussion, consideration of the fact that the petition obtained is higher qualification
Even prior to
Even
the
prior
issuance
to
of
the
the,
issuance of last notification, he cannot be denied benefit of higher scale of pay.
in my case, same thing. The selection process is of 99. Page 78 is the panel. The panel was prepared on 23rd of February 1999.
But your service was terminated. That's the point.
True. On the strength of the,
1999 it was terminated.
if the decision of,
2023
if the decision
of restoration, the difficult issue. Portion of difficult issue.
on a wrong understanding of law, it was terminated.
No, difficulty is this, that the view taken at that point of time was a possible view. Now the judgment has been delivered. And here also, we have said very categorically that here he was admittedly in service. You were in service.
I was in service. My service was approved by the government.
No, it was it was terminated because of what? You don't have the required. It was a
No. As I got the degree from Himachal University,
for high scale of pay or for
No.
But see,
For the approval of the final provisional approval was panel was prepared. He entered into the
Finally
service,
turns to be
and final
78.
approval was not granted in 2000. Because already in 2000, that March 2000.
There is no word provisional. Page 78. After careful consideration of his proposal on the subject mentioned above, the understanding is directed to say that the following panels prepared by the selection committee of this institute for the recruitment of one lecturer in mathematics under so-and-so is hereby approved.
No, you have said in paragraph 18, equivalence of a degree obtained through correspondence course. Equivalence of a degree obtained through correspondence course with a degree obtained through regular course and the recognition of a degree obtained through correspondence course by the state for grant of financial benefits are two different issues. So we have two different issues.
Yes.
So we made a distinction that if at the entry level, because at the entry level we have not decided that issue. Because here the person was already in service.
Yes.
He paid for high scale of pay, which Justice Ray has also considered.
Absolutely.
But we have not decided here because you see equivalence and recognition are two different things. One may be equivalent. That is precisely what Gita Gu has said, in fact. So,
Gita Gu is annexed to the petition.
Yes. So Gita Gu has also correctly said that if you read paragraph 41,
Lordship,
apart from that the learned single judge held that it is not enough if the qualifications are equivalent, it must also be recognized as equivalent. Paragraph 41.
41.
It must also be recognized as equivalent. Now, whether it's equivalent or not, I may give you a recognition for the purpose of higher scale of pay. But at the entry level, suppose we don't consider it to be equivalent for the particular post. That's for the university to decide. We cannot go into that question.
Very well. Now, I want to take your lordship to two pages. If your lordship kindly turns to page 73. Sorry, 74.
So it is the university, or they have to they say that we are recognizing it. Equivalence is not good enough. Recognition for the particular post, we consider it to be a recognized degree for that particular post. That is why even in Gita Go, no relief was given as such.
But if
Gita Go judgment,
paragraph
36.
I've gone through. Now, my lord, if your lordship kindly sees my lord's special bench judgment once.
Yes.
My lord, last but one paragraph. Para 21. In view of the above discussion and consideration of the fact that the writ petitioner has obtained his higher qualification even prior to the issuance of the last notification in recognition recognition dated 21st of March 2000, he cannot be denied of the benefit of.
Absolutely.
Yes. My lord, what is my case? My lord, I have
At
moved
the
the
end,
writ petition.
see, we cannot invalidate a decision
Huh.
unless there is a malafide attached to it. There is no malafide. In 1999, see, what happened is this: when the 1994 notification was set aside, 94 notification said that we have referred to the 94 notification.
Yes, earlier.
Denying recognition to degrees obtained through correspondence course. So only thing you need to decide, then when this 19 December 94 was set aside and till a new notification comes, recognition to degree, because here for this purpose you are required to take into consideration the recognition of the degree. If you recognize the degree, then he becomes eligible. It's not an equivalence.
Recognition.
Recognition. If this 19 December 1994 notification goes, and there was then by implication this disability goes, then his case, this case could not have been rejected in 1999 because 94, because your decision is based on 19 December 94 notification.
It goes.
My lord, I have to take instruction as to whether this appointment was given, that is a provisional in nature or final in nature.
Provisional, what is not there?
Because your lordship knows when a person enters into a service, it's obviously it gets a provisional appointment.
No, if it is a provisional, then it's a different issue. But if it is permanent in nature, then it
That's
cannot.
why because all appointments are given at the very threshold stage at the
So
provisional.
you find out. You are for who? You are for
I'm for the state.
any.
Actually, the Ramakrishna Shiksha Mission has to find has to give a reply whether that initial appointment was professional in nature or final in nature.
Very good. Take down.
Where is he?
Yes, Mr. Ranjoy. Mr. Ranjoy, there was there. You have heard the land. It is restoration program. They were active. You have heard the land council for the parties. Prima facie it appears that few of washing off the notification on 19 December 1985, 1994, by which recognition to degrees obtained through correspondence course from Himachal Pradesh University was denied. No reliance would have been placed on the same notification at the time of
আমাদের একটা হিয়ারিং নিয়ে শেষ করেছে শোনা যাওয়া
কিন্তু রাজ্যের যে জাজমেন্টটা আছে না
না, না, এটা এটা কোনটা দিচ্ছে?
হ্যাঁ,
এটা
দিয়েছে তো,
একটা
দিয়েছে
বড়
তো, রাজস্বী
দুজনে
রাজস্বী বসু দেখুন আছে। হ্যাঁ, অনির্বাণ দত্ত, রাজস্বী বসু, অনির্বাণ দত্ত, ঠিক আছে, উইথ অনির্বাণ দত্ত। উনি স্টেটের হয়ে নেই, আমরা দুজনে স্টেটের হয়ে আছি।
আচ্ছা আচ্ছা ছিল নিয়ে গেছে কমপ্লিট হলো
For hearing item 181,
Please give us a time frame, how long, because we don't want any repetition. There is also a time constraint. All of you have not filed your notes.
Lord, what happens is on 25th August, Lord, we have been served with a copy of the affidavit in opposition. So, Lord,
Just a minute. My notes. Just a minute, there's a one part matter is there. We'll just.
181.
এটা কি আছে বলতো? হ্যাঁ, where is Dr. Patra? দিয়েছো, দেখিয়েছো, লিস্টে দিয়েছো? Dr. Patra. Who is for the writ petitioner? ছেড়ে দাও, make it not today. বোর্ডে দেওয়া ছিল তো? Yes, so
item number 182,
so please tell us who will be the lead counsel
182 to 195.
and who will be supplementing it.
Pardon me, Milord, before your lordships going to that aspect, Milord, we have a problem. Milord, created, Milord, by the filing of an affidavit in opposition on 25th of August. Milord,
By whom?
By the writ petition.
by the writ petition. Milord, they were given 4 weeks time and we were given 4 weeks time for reply. Milord, they took me a long time and only on 25th of August they have filed this affidavit in opposition. Milord, taking, Milord, various grounds, Milord, which according to us are Milord, something which was not there in the writ petition.
They have completely given a go by to their case in the writ petition. Now a new case has been made out.
That has to be dealt with, Milord, in detail.
The judgment itself, our contention was
But will not allow you to counter, you will not allow you to interpret anything which is, will only strictly go by the or by the trial court records.
yes,
So no affidavit is required.
Because the particular application filed by the board, some documents were not added. The documents were the part.
So if they are part of the trial court record, yes. If they were not, no.
Yes, part of the record.
Yes, you are for the board.
I am for the board.
I disagree, Lord, that everything was part of the trial court record.
I have,
Milord,
All for the record.
Milord,
go by the record.
immediate question for consideration is this: whether the trial court has at all considered any of the documents. Trial court, this is the case. Trial court has not considered any of the documents. Trial court has proceeded in its own way by calling witnesses, examined and delivered the judgment.
and
They
he-
have
and
not
he-
relied
that's
upon
the-
And that was not, the first question is whether what is the scope of the writ petition? Today at all remains at all.
They have
For any adjudication.
certain charts, Lord, which were not there. And Lord, they are trying to now show that this percentage of persons were given precedence without, Lord, there being obtaining certain numbers. Lord, those are issues, Lord, factual issues, which we have to deal with in an affidavit.
If these are fresh materials, then it's something else.
No fresh materials.
These are fresh materials.
Fresh materials. Absolutely new documents which I have annexed. These documents will not. New allegations have been leveled.
These records of the. No, were they before the trial?
These documents for the one trial judge.
Then how can we get?
We have collected it from their website. Then it was annexed.
No. How do you know that these form part of the record of the trial judge or not?
Yes, it was at the time of hearing, my.
At the time of hearing before the one trial judge,
No, একটা 187 জনের একটা নাম ডিসক্লোজ করেছিল কিন্তু এখন ফ্রেশ চার্টস
In that case, the learned trial judges, Milord, Lordships kindly call for the records of the learned trial judges record.
Lord, I also filed an application, Lord, there is scan, Lord, 5 of 2023, Lord, filed in board's appearing at 192. Let the application be also checked. I also saw the copy of the.
What is the application?
The same 5, 6 and 7. Addition of parties of person was filed, Lord.
Addition of?
Addition of parties.
কোথায় মিনি ইয়েটা কোথায় গেল?
And it was certain other restrictions are also
Judicial
pending, Lord,
review টা
of
কোথায়
similar
গেল?
Those who have joined, Lord, is these applications, Lord, which I have filed, Lord, the can 5 of 20.
They are parties in other proceedings. Want to.
Yes, our 4 restrictions are pending. Those are on a trial.
And let it remain pending.
No, but this affidavit opposition which they have filed, they have disclosed one notification of 28th November 2022 and the depositions before the learned single.
In fact, I didn't have the opportunity to go through it because my learned juniors are preparing their reply. Mr. Kaur has gone through it, and I have heard it from Mr. Kaur, Milord, that they are annexing various documents, Milord, including particularly a chart, which I have been told.
That is annexure R8.
Lord, before that, kindly, Lord, have a look at page 129. I don't know which opposition your lordship is looking at. Is it MAT 873?
The opposition position.
Only
One
opposition, Lord, we have used, Lord.
This is, Lord, one chart where, Lord, they give certain, Lord, the allegation is that these persons have been favored.
It starts from that page.
It was part of the.
Then,
No, no.
then, Lord, page 131 onwards.
No, this is a back sheet of affidavit in reply.
These documents.
Oh, Mr. Tiwari, page 130. So this was possibly formed part of, I don't know what is that.
These documents that we have used in the trial. Unless
No, but-
it was not.
No, but then what is this? Why you have given this particular page? Page 130?
130.
Page 13, 130, Lord, is a part of the reply.
But you have not given you annexed the reply. Where is the reply? Where does it start from? It cannot form part of the reply.
The reply start page 119, 119, annexed R4.
How it can?
Lord, this is a reply which he had filed before the trial court.
Yes.
But, Lord, we had no opportunity to deal with this.
It's a different issue. So this was part of the trial court record.
Lord,
Every document.
We are on the, whether
Lord,
this was
point,
part of the trial court record or not.
Lord, point is, Lord, we had no opportunity to deal with this.
Yes,
That's a different thing.
That
That's
you
what
can
we
always
said.
argue, that's not the point.
No,
Then from 131 to the rest,
You need to file affidavit in reply for.
131 to the rest,
get
were
an
they part of
opportunity
the
to deal
trial
with
court
this.
record or not?
So far as page 131 is concerned, Lord, it's not the part of the trial court.
Correct.
Then why you have, on what basis you?
Page 133 onwards. These are the, Lord, part of the trial court. These, all these, Lord, sheets, Lord, from 133 to, Lord, page. Lord, 184.
এমনিতে আর তুলেছে হাতে হাতে।
no, where is it filed?
Trial court record.
I have no.
Where it has been filed? Is there any affidavit?
But these- They are there before the trial court, those they should. they
Milord,
can-
some documents were handed up,
By the way,
not on oath, not on affidavit, some merely handed over to the court.
These set of documents were not supplied to you.
No,
No.
Lord, we were not there before the trial court.
the teachers were not there.
We were not before
We
the.
are not there now. Milord,
Not about you. I'm saying on the board.
Board, I don't, we were not there.
Board,
in
you
the-
are there.
Yes.
So you can say that whether these documents were produced or
Milord,
not.
these documents were handed up, authenticity of it, Milord, never questioned.
But you have a right to now see that they are authentic or not.
Milord, I have to deal with these
Yes, you have to deal with this. So no, I just want to
in
find out
my reply.
whether they are for the first time annexing some documents which are not before the trial.
Milord, may I just submit one thing?
I will say those were not produced before the trial court in the manner, Milord, the law recognizes. They're simply handed up, Milord.
It is not being recorded in any order that these documents were handed over to the court.
Yes, recorded in the order. And that is our challenge.
But if it is there, you are agreed by it. then
That is precisely our
you are
challenge.
agreed by it, they should have come up and appealed there and there that these documents were taken into, because you allowed these documents to be there on record and allowed the learned trial judge to
Where do I
decide.
get time? The matter is hard, judgment passed, and compliance within.
No, so yeah, according to that,
Even
you
by
have-
12 at night, complete.
There's a reflection.
15 days, 15 roads.
Very well. No, very well. So 133, see, if the record will speak for itself. If these documents are authentic, then you cannot have any objection. You may have given interpreted that's a
Milord,
different.
I am not sure of that. But how can a court
So you
rely
file an
on,
affidavit, no problem.
how can a court rely on some documents without being,
Delay to
being produced by way of an affidavit? And the court
No,
has-
sometimes we direct that you produce the documents and on the
Milord,
basis documents. Unless you object to it.
Milord, a few pages, Milord, we can look to it.
Very, you see.
But this was a spiral, spiral.
You see the court is exercising the certiorari jurisdiction. Can
Yes.
call for the record.
Certainly is, but we have to.
All that you have to find out, now that the appeal is required to be heard, all that you are required to find out whether these documents were really genuine or not. If they are
Milord, most
genuine or
of them,
authentic, and their relevance. And their
whether they are
relevance.
authentic and their relevance, this has to be found out.
This is
That
what
is not, we
incidental.
to file a reply, Milord. We are getting the opportunity for the first time before your lordships.
Incidentally, just let's just consider, we are spending times on these documents, whether relevant. The question is, whether the single judge has at all considered this document. The question, not. Now, today, can you appreciate this, Milord? Today, the learned judge has not written upon. Your lordships will not find from the judgment in point. Now in the appeal court, when it has been stayed, now they are trying to develop a case here. Milord, can you see the scope of the writ petition once?
Banerjee, it's not about that. Once the documents comes up and form part of the record,
Correct, Milord.
the court is duty bound to find out whether, because it's after all a public recruitment process. It's after all a public recruitment process, there should not be any hide and seek in it. So the question is this, that in all fairness, is a board who is the main answerable person. You have got the job. Now you may have, some may be genuine, some may not be genuine. So your case also falls or stand on the basis of what the board actually says on the affidavit. Because if you get the entry, an unfair means, or some illegality, or whatever the irregularity, that cannot be perpetuated. So the only person who can throw some light on this is a board. So board has to file an affidavit.
I am not making that. Really similar. Your lordships is absolutely correct. Well, I am grateful to your lordships, Milord. But there must be a finding from the court.
Yes, that-
Let me spend 1 minute time. Let that these persons have got the no. All these 32,000 persons have got this employment by undue means. Where is this finding? That's the question. Question is not that, Milord, can you see? Some person has been arrested. Milord, this is the idea is being thrown out everywhere. The perception is grown up. Milord, in a rule of law, in the court of law, nobody goes through the perception. What is going on surrounding basis? Everyone will go by the, Milord, on the basis of the legal provisions. Question is whether these 34,000 have got the employment undue means. What is this finding? Milord, what is this finding? That's the one thing.
This is why it has been entertained by the Supreme Court, and
Absolutely.
you are enjoying a stay.
That's a intimate is expiring in this month.
We'll extend it. There's no problem.
Page 110 once.
আমাদের অর্ডারটা দেখি।
Page 110 of my application.
Well, fast in 19 May 2023 and then
23rd August last order.
last Judge Sahib did it. 23rd August.
অগস্টে বোধহয় অপোজিশনের কথা কিছু বলেন, তাই না? টাইম চাওয়া এক্সটেনশন কিছু চাই। দেখো তো 23rd অগস্ট।
আমাদের অর্ডারটা করতে হচ্ছে।
Milord, your lordship's order was on 23rd August 2023.
Possibly no prayer for.
Milord, not in this. কোনটা দিয়েছে Judge Sahib? Can you take this one, Milord?
Lord, that was in MAT 1520. Your lordship had.
My lord, in my, that order was passed, Milord, in an, Milord, that order was passed in another appeal. That's the Indonesian Shah. Kindly take this one. Milord, that is there we have.
One is Dipankar Sinha, who is Shingho. Yes.
In this matter, late by Mr. Shoptangshu Basu.
Yes.
Well, before, prior to that, Indrajit Sinha was taken up. Kindly take up.
No, first or was taken up by Dipankar Singh.
No, no, on that day, Indrajit.
Indrajit Saha.
Before 23rd. 22nd one.
Matter, they have not filed any opposition matter.
In this matter, no opposition is filed.
No, in our cases also, no opposition has been filed.
As board appeal is concerned, we have filed our opposition and will be relying on these documents in respect of
Others. So we'll record it.
I pray, my lord, for leave to file appeal, my lord, and my client has not been made a party.
You file it.
And my lord, unsuccessful candidates are coming.
No, but you have you filed your leave to prefer an appeal?
We have filed our appeals on
183 to 185. Let it be clubbed together.
No, you have filed a leave to prefer an appeal.
Yes.
You are successful.
Yes, yes. We are in the same boats.
180.
No, we got the employment 7 years back.
Just a minute.
The judgments have been delivered. Single judge, Justice and Justice. What is it?
Mr. Ghosh, 183 is, which is your application?
Joydeep Majumdar.
No.
Item
number 183.
182, 183, 184 and
No, 182 we have allowed. 182 we have allowed. The addition of part.
Lordship, 182 is 1616. I'm
183,
183.
183.
Mr. Ghosh, you are appearing in which matters?
183 to
I'm
180.
appearing in 182.
183?
He is appearing in 183, 184, 185. I'm appearing in 182, that is Sudeep Malakar.
I am preparing for 186.
Just a minute.
I'm sorry.
You are appearing in?
182, Lordship. 1616.
No, 182 is different matter in which Mr. Saptangshu Basu is appearing.
He is appearing in 183 perhaps, my learned friend.
Yes.
166 is 1616 is not 183 serial.
I'm so sorry. It's 1616 is 183.
We can allow the leave to prefer an appeal. That's can be allowed. Yes.
I have also filed an application. We have also filed an application. Can I file it in section 5, 6 and 7?
এই প্রত্যেকটা দেখো তো leave to prefer.
Is Lordship 183 serial number. I'm appearing in that 1616 of 2023 along with CAN 1, CAN 2.
ক্যান গুলো দিচ্ছ না কেন?
Order was passed in 15th August.
এখন দাঁড়া
6 years.
Section 5. 22. 183, there is a delay of 22 days.
Now we are taking this, who is in this matter? Sudeep Malakar?
Yes.
Sudeep Malakar, who is appearing?
I'm appearing for Sudeep Malakar, Lordship. Sudeep,
Lay down. Can one take it? Can one take it? Allowing this application with the condonation of the
Lordship. 184 is with you, sir. Apni 184 আছে।
Malakar.
Malakar is 183. আপনারটা 184. অভিষেক ঠাকুর
Applicants similarly placed
আর 185 sir.
as that of
আপনি 184 অভিষেক ঠাকুর
and others
অভিষেক ঠাকুর 184 অভিষেক
who are
ঠাকুর
appellants.
আর একটা হচ্ছে
MAQ
সায়ন্ত দাস 185
1109 of
এটা আপনার
2023. We have allowed Dipankar Singh and others. We have allowed the application filed by Dipankar Singh and others for leave to prefer an appeal. The grounds being same and identical we allow the application for leave to appeal upon condoning the delay of
57 days in 183, Lordship. That is 157 is the page number. Tan 1, 157 is the case number.
এই শোনো
আপনার delay গুলো বলে।
37 days, তাই তো?
ক্ষমতা খাওয়াস নাকি তুমি?
Sir, এই যে,
দেখো তো কদিনের ডিলে লিখেছে।
Handing over the affidavit of service, if it may be recorded
এখানে কোথাও windows
in 183.
এই শোনো prefer the appeal within the period of limitation, and also having regard to the fact that the Honorable Supreme Court has allowed persons affected by the impugned order, the delay of 57 days in preferring the instant appeal is the norm. Put a leave to prefer an appeal to the memorandum appeal will be there, and if you want to file any notes, you can file it as a different. Unless you want to.
Lordship, only one thing, two prayers. One is whatever the board will provide to this court will have a bearing on us. Whatever the board files.
Malakar. In opposition
Absolutely,
to the
Lordship.
writ petition,
Absolutely.
and reply you can file.
We have to file our
If you want to file opposition to the writ
petition.
because the stay has been filed by the board.
We have also filed our stay.
That's what I'm saying.
Huh.
So
Yes.
basically, your memorandum appeal will be taken into consideration.
No, Milord,
Your stay.
we have, this is practically the first court, the division bench directed that the applications, an appeal would be taken up for hearing. Kindly appreciate this, because in the applications, we have given all the documents.
You have not filed any stay.
We have.
You have filed.
No, we have not filed
No,
any
you have
stay.
not. That is what I'm saying.
We have not filed, but Lordship, there's only one thing. I bow down to what my senior is saying. We would also like to have at least access to what the board is supplying the court with, what's being filed with the honorable court, so that we know exactly what is
You
happening.
must stand or lose on the basis of your own pleading, not on what the board says.
No, I understand, Lordship. Only thing is the old pleadings, if your Lordship gives us an opportunity to at
They are
least
made available to you.
file an affidavit with you, whether we have an leave to
Affidavit
file an
what?
affidavit
Affidavit to what?
to the origin, because we were not parties. The original. Fine.
But
at
you will
least-
be heard, that's all. You will
Only
be
thing, Lordship, one leave. If the board, whatever affidavit exchanges, we can have a copy of it, so that at least we know what exactly is before the court and what exactly is going to be argued upon.
heard.
The board can, I think, fairly share it with us.
Yes, আমাদের কাছে কখন
The affidavit to be filed by the board in FM
appear for the appellant.
Oh, sorry, 185, give us 185.
ওখানে কত আপনার 180
কতদিনের delay আছে দেখুন। One.
186 I appear for the appellant, but in this matter, on the 20th. Filed by my senior Mr. Bandyopadhyay, which your lordship was kind enough to pass an order.
That order I have handed it over.
Paragraph 10 kindly sees. Paragraph 10 and 30.
What is your can one?
Can 1 is an application for leave to appeal and without a connected application.
ওগুলো allow হয়ে গেছিল তো।
Stay.
ওগুলো stay-
Can one টা দেখি, can one টা দেখি।
Can 1 in connection with 934 is a stay application. আরেকটা application? Stay application. This appeal is within time.
All of you are representing the respondent.
এটা 185 is
Read petitioners.
Respondents are concerned,
Give the names, give the names. So it cover all the.
Miller, kindly record one, Miller, notice of
Just tell
appeal
me,
be
let us-
dispensed with in all appeals kind.
Yes, we are dispensing with all.
All in all
But
appeals,
we have to record the names.
in all appeals.
File a copy be handed over
You are representing, you also give whom you are representing. Union of India, Union of India,
My lord, one
They-
submission, my lord.
They have no role to play.
Mr. Mary Dotto appeared. Miss Mary Dotto, she is there. Very well, very well. Orko Kumar Nag is there
Orkonag is here. Orkonag nahi?
Orkonark is appearing for the state.
and Mr. Atul Vishwas, yes, Union of India, State and West Bengal Board of Primary Education. Yes.
Okay, okay.
one thing I need to tell you a lot. There is an application in connection with not the appeal, which is a stay application. Not the prayer for leave to appeal has been clubbed together in the same thing. A formal leave is always required.
But stay is already there, so.
Kindly track the matter along with this.
No, we dispose of your matter, only your memo appeal would remain, stays there.
Only one humble request, my learned friend, Mr. Tiwari has filed some affidavit, a copy we served on this. So, another thing.
186, sir. There is no condonation of delay.
There is no condonation of delay, but stay and leave to appeal clubbed together in one application. Only one thing, in the last order passed by the Honorable Supreme Court, apart from the appeals, filed by my senior, there were other appeals, which were also directed to be listed if they are filed. Incidentally, there are certain appeals appearing under the heading application before your Lordship's court, under 2023 heading. Those item numbers may kindly also be tagged together, which is the same issue, same order, everything is same. But the parties are different. I can give you a lot, indicate to my lord's office of the name.
Just a minute.
One eight seven. 187. 187 will see.
187 টা হয়ে যাবে same as
187 is not.
187 What is your can three?
187 affidavit of service. Saurabh Bashak.
No, but what is your can three? What is can three? The order has already been stayed by the Supreme Court. So why you file a stay?
Because of the pendency of the appeal,
The Honorable Supreme Court has already stayed.
limited.
It's not limited period. Why you have filed the stay? You see,
On before passing the Supreme Court order, we file it before Supreme Court order. On
In view of
fourth
the-
July, you have filed.
in view of the order. One and two was disposed of.
Yes.
But this appeal shall.
One 189, my lord, I am for appellate led by Mr. Joydeep Kaur.
189. My lord, I just tell you, lords, 189, 190, 191 and 192. These are the four matters, my lord, the lead matters.
Lead matter.
Lead matters. 189, Mr. Joydeep Kaur argued. 190 and
181 is not the lead matter.
my lord.
181 is not the lead matter.
No. These are not lead matters. They are coming later.
181.
181, no.
Mr. Gupta is a,
181 is the West Bengal. This is a different matter, my lord. 181.
sorry, 182.
No. They are coming later on. Amna,
9.
189, 190.
189.
Then Mr. Joydeep, my lord, these orders have been passed there.
No, 189 has not been disposed of. What is this application, sir?
Leave to appeal application.
You are a party. Why you need to prefer an application?
No, I am not party.
No, my lord, I just tell you, my lord, no, 189, we preferred leave to appeal earlier. That order was passed on 19 May.
It is arising out an order of 11th May.
Exactly.
So that this application has now become, because final order, what is the order?
No.
Date of the order.
I tell you, lord, kindly see the order of the Justice Division Bench, my lord. Division Bench passed on 19 May 2023. Your lordships will find there 19 May 2022, my lord.
Disposed of.
Yes.
এটা কেন বিশ্লেষ? তাহলে এটা কেন
Yes.
দিয়েছো?
Lords, my lord, let me read this.
কেন দিয়েছো তোমরা বলো তো এটা হচ্ছে?
ডিসপোজ অফ, কিন্তু ওইগুলো অ্যাপ্লিকেশন
চুপ কর না, চুপ কর, আমি বলছি চুপ কর। আমি যখন বলছি তখন একটু চুপ কর না।
Yes, 874. Yes.
Disposed of.
190, 191 and 192.
Yes.
No, just a minute.
And also, Milord, the Supreme Court has directed, Milord, directed to decide the MAT number 890 2023, 874 of 2023, and 873 of 2023 and 890 of 2023,
Achha.
or any other case filed along with that. These are all the time it has been treated.
The applications are appearing by mistake. All the
One ninety.
890.
190 is my matter, Milord. 190
Yes.
disposed of.
File three applications for addition of party.
No, in 890, there was can 1, can 2. Can 1, can 2. What is can 3, 4, 5, 6, 7?
Addition of party, those matters were pending before the honorable single bench.
Milord, that we are opposing. They have not been added as a party anywhere. I don't know where is the applications. Where is the applications? Where is the application? Milord, we are.
Why this can 3 has come before us?
My lord, appeal is pending. Appeal is pending, my lord. We have to add unless and until we
Can
have been
three
added,
reach
my
it?
lord.
Can three koi?
Cannot ventilate our.
Milord, that I am opposing this application.
You are trained or untrained?
Non-trained.
You are successful or unsuccessful?
Unsuccessful.
So at this stage, we don't find that you are required to be heard.
The writ petitioner before the single bench.
Maybe
No, you are not the writ petitioner before
you
the
are not the
single.
writ petitioner.
No.
You are the writ petitioner.
Milord, they are writ petitioner.
3, 4, 5, 6, all are the writ petitioners which are pending before the single bench.
Pending, let them deal. That writ petition be heard first.
But that writ petition is involving the same question.
Pardon me, Milord, that's the question. That's the reason the question is, Milord.
No, so you will be allowed to make your submission. That's all.
That is the question, Milord. Can you appreciate this, Milord? After
That issue, Mr. Bandyopadhyay, we have to decide in the appeal whether these unsuccessful candidates would have filed the writ petition and got the order.
Correct.
So they are also, so these issue, whatever we decide here will also be binding on them. So it's a common issue. We are not adding them as parties.
That's right. Exactly. Then let them argue. Let them argue. Let them intervene. That's the
Petitions are pending. Those petitions are pending.
Those writ petitions are possibly died is natural death because of the order of 90 of the 11 May. Because virtually 11 May dispose of their prayers as well.
No,
Unless they have different.
কি প্রেয়ার ছিল ওদের ওদের পিটিশনটা দেখি ওদের অ্যাপ্লিকেশন রিট পিটিশনটা দেখি ওদের অ্যাপ্লিকেশন
So addition at this stage is not required because the learned single judge has not disposed of those writ petitions on 19th May. But see, one group is good enough to argue because there is no, because their cases is not different from.
There are some difference.
For the timing, we don't want to enlarge it. Those cans will not allow those cans. We'll decide it, then we shall. It's a broad questions of law, so you're not required to be.
Kindly don't allow them to jump the queue.
No, we will not allow.
We are not asking for the action.
It's not required, Mr. Bhattacharya. We'll unnecessarily will not. Whatever we decide, that will be because the learned single judge has whatever we'll decide in the main matter. We'll cover all. Yes, you are making submission. No. For all it cannot be. It is not a public platform for everyone to come like a parliament and make their submission.
Parliament excepting parliament.
3-4, we are not allowing this, Mr. Bhattacharya.
But the only difficulty,
they will really remain unrepresented.
No, you will be very much represented in 181, 82, 83, 84, all of you are.
not having the entitlement to get the documents.
The difficulty is because there are many writ petitions filed on the same issue.
So one issue is good enough that will cover everyone.
That's why.
So the main lead matter will hear, others will abide by.
Yes,
Unnecessarily, we don't want,
kindly-
no, sorry, we will not allow.
Kindly give us leave.
Can,
Milord.
can,
No, we must be thankful to Mr. Just 1 minute. Mr. Wadini, I must be thankful to Mr. Wadini.
can 4, can 5, can 6, can 7.
You are allowed to argue before.
Yes, you will be allowed to argue in the other, no, not in this can. The main matters are being taken care of. Can 3, can 4, no.
No, main matter, Lordship will tell you.
That is already, you are there. That is, you are already there in
We
the.
are not there.
No, no, you are the writ petitioner there.
No, we have, our repeat are pending, which has already decided.
Question is this, whatever is decided, those will hear. What has not been decided will not hear at this stage.
But then this
Then
judgment.
no, maybe, but those matters, the Daniel Single has not said, he could have said that these judgments are, these applications are disposed of on the basis of my order. Not at this stage.
But Lord,
have to agree
the
all.
court Lord has reopened the whole issue. Kindly see the order of the.
Not at this stage, not at this stage.
Then
Not at this stage. Because the main writ petitioners who are there will hear them, no problem. There is a question of untrained, they have come after 6 years, challenging a recruitment process of 2016. The ground is that they came to know of this because of the board's some report of 2020 or 21. So that possibly gave a cause of action.
Not even that.
Even this.
Not even that.
Apex court judgment is also not.
This is the court.
Malad,
Yes,
we are
yes,
all
yes.
being agreed,
Main
my lord.
petitions are there, others will not multiply this.
I do not want
No,
Lord,
We
the.
want this can
No,
three,
no,
can
no,
four,
I am not
addition.
on that. Probably I am not clear to the court. I am not asking the court, Milord, to add or adapt the Milord bundle of the records.
Correct.
Kindly allow us to Milord make
No,
submission.
no, you are there, Mr. You are the writ petitioners.
No, sometimes he is there,
sometimes.
That will be unnecessary.
Lord, the Honorable Supreme Court has said, Lord, the aggrieved persons, Lord, to be paid as
You
part.
are not aggrieved.
You're not
Lord,
aggrieved.
Ultimately, Lord,
Aggrieved to the
the
judgment.
effect
You are
of the
not
order,
aggrieved.
Lord, we are aggrieved.
No, no,
The
no.
whole issue.
You are not aggrieved to the judgment of the single bench.
Deciding and
You are
point
not
of
aggrieved
law,
to the
Lord, in a
judgment of
broader
the
sense,
single
Lord,
bench.
the persons who were since inception before the court, Lord, all are aggrieved part. So, Lord, subject lordship kind sanction, if your lordship at least allow us, because the point may differ, Lord. The point, Lord, which we have taken, Lord, in the application, that has not been taken by anybody. Lord, I can show, Lord, instances.
Then go and you have seek a appropriate adjudication there.
No, Lord, that
By
adjudication
derivation
is.
of what is submitted, it has to be heard by the learned signature. Take down.
The learned signature,
grateful
Lord.
to you.
No, your
Take
lordship would kindly appreciate, Lord, the learned
Can 3,
signature.
can 4, can 5, can 6,
The
can
read
7.
petitions are
No, no,
pending.
I am extremely grateful to you. Can 3, can 4, can 5, can 6, can 7. The learned counsel for the applicants have submitted that they stand on a different issue than what was decided in the main petition.
Not different stand, my lord.
They stand on a different curriculum. Yes, no, curriculum, the applicants, the learned counsel, the applicants submit that their grounds of challenge are different.
No, Lord, it's not that.
Then
No,
bound by
it is not that, Lord. Challenge is
Bound by
not the same.
Sorry.
Challenge is same.
Can 3, can 4, can 5, can 6, can 7.
We can't allow here.
In view of the fact that the writ petitions are pending before the learned single judge, and having regard to the fact
No, it's not. Lord, the challenge is same, Lord.
First, what you
No,
say.
Lord, I said,
First, what you say.
Lord, I said, Lord, there might be some points which may not be argued by.
We are not here on polemics. Either you decide that you have a point or you don't have a point.
Lord, I have a point
That-
similar with them.
Then you are not required to be. Why
Lord,
you?
in any, Lord, we are asking for, Lord, at least, Lord, liberty to hearing, Lord. Because ultimately,
You
whatever
not
the
allow
outcome,
6 councils to make submission. You decide one council will allow,
Lord,
but don't allow 6 council to make a
Lord,
submission.
yes, Lord, one council, your Lordship would kindly allow us to represent.
Can 3, can 4, can 5, can.
So it's, yes,
We are only giving a chance of hearing.
that's right.
Obliged.
Can I am just.
Can 3.
Disposed of.
Yes.
That's
same-
our
same-
stay of the
same-
Now 192. Apnar.
192, my lord. This is board's appeal.
Same thing disposed of, no, same thing disposed of on 19.
At 873, my lord.
I just. At
It's
873.
yes, my lord, it should be in an order like 190.
873, 192.
My lord.
192 will be same as 190.
Same as 190. ঠিক আছে?
Order
Only
should
one
be same.
present charge.
190 and 192. Same order.
190.
No, 192 is same like
4, 5,
190.
6, 7, 8.
The 4 petitions were pending before the learned trial. On the basis,
6 years you are snoring.
only one. But
6 years you are snoring.
only one thing.
Mr. Theory is trying to put some words in your mouth.
On the basis of the
On
order.
the basis of some explanation he wants to give.
Order passed in those petitions will not board disclose certain documents. I just wanted to will not annex those documents so that will not it will be benefited for all.
No, but have you filed any application?
Yes. There is can 5. Can 5 of not 873. MAT 873 can 5 of.
What is can 5, Dekhi?
আমরা কি বলছো? Can 5 copy পাননি বলে?
My lord, copy has not been received by us.
Yes, sir. Copy, sir.
Well, then in that case, they should file, my lord, if they, my
What
lord,
is the
my
application?
lord, kindly see, if they take a stand only one opposition cover everything, then they should file the copy of the application should be served to all. We should know. We should know. We don't know anything.
So far as scan 5, Lord, my application is not in the list, Lord.
Yes,
It's not in the list.
yes, scan 5 is there.
Series of applications, starting from 1 to 8.
Well, let them serve the copies.
Tiwari is not getting time. After the TV interview, he cannot get a time to find out whether these are there or not.
That is the reason Mr. Senior Theory is there.
It already disposed of.
And
Also correct the prayer. Typography error is there. Yes, so no, say addition of party, no, but whatever we said, only one representation.
so far as this addition of parties are concerned, Lord, these-
You have filed a writ before the.
Yes. Now, on the basis of the order made by the London Judge, my lord, the board has disclosed documents. Well, I want to rely those documents, well, by annexing your documents in this.
Milord, he has used an affidavit. He just now said, Milord, a few minutes back, that he will rely on that affidavit for all the matters.
No.
Board has published.
Just a minute, if these documents are already there in your affidavit,
No, they are all documents.
why you have not?
All that. All documents.
Why you have not? Why you are bringing document from your pockets?
No. Whatever the board has published on 28th of October. This is the one of it.
These documents are not before the trial court.
And not, it was published.
These documents were not before the trial court.
Yes, before the trial court.
How it could be?
23rd of May, board has published these documents.
23rd of 23.
In other matters. In other matters, which court?
If it is already there, why your duplication? Don't.
Not there.
That is the reason we filed the application.
In the affidavit of application, we could not annex these documents. Now, these documents were annexed in this application.
No, but why you have not annexed this in the affidavit of opposition? Why you make a duplication of this?
These are not part of the record, so far as.
That's right.
At that point of time.
So this is a fresh material.
Yes,
Yes, material supplied by the board.
that is the reason we filed.
Supplied by the board to whom?
Good to us. To us.
When?
The applicant.
When? By?
Fresh
By?
material supplied by the
by
board
which-
to the applicants.
In which proceeding?
Order passed by the central judge. In a
Where we have said,
In which proceeding?
We should know the applications. What is the application?
where we have said.
Lordship 11.
Sir, the application, copy of the application. If the stand is that one opposition will cover everything, then the application should be served upon us.
Where is your?
No one affidavit will serve.
अरे affidavit तो no, one opposition ना, वो तो opposition
Where you have said
সেটা কি
so.
বলছো?
Paragraph 9. Yeah, have you been served, Mr. Gupta?
It was served.
Possibly not, Milord, I'm not sure.
Been served.
Mr.
Been served.
Bandyopadhyay,
It may not
we are
be served
considering our
because
board's application.
the board.
Kindly excuse me. Kindly excuse me. What is the stand of the petitioner? Kindly excuse me. There was directions for affidavits. In all appeals. They were saying no one affidavit will cover everything. That the affidavit is used in the postgraduate board of secondary education.
This is not.
We should also get.
You must either you have not read the brief, or you are not conversant with it. What you have said, part of annexures, copy of documents prepared from the data uploaded by the board showing last. So this is not supplied to you. Just now you said it's a
That was Milord
either you have
uploaded.
not read it.
Uploaded.
That was not available.
Uploaded, Milord.
Just a minute. You have said
Yes, sir.
we will not allow this. Sorry,
That was uploaded.
sorry.
taken
Whatever the
board
documents, we will not allow any
That was
section.
uploaded, we have taken
Sorry,
the board's
sorry,
website.
sorry. Board is to
Public
produce.
document, Milord.
Board is to produce all documents. If
These are public
these documents are not there, then we shall see to it. Take down.
post with me. So
it's not
part of trial court record. Milord, let it be kept pending, Milord, in that case.
They have prepared something out of.
These are all public documents, Milord. These are all uploaded in the board.
There has to be a proper procedure for this. This is not the way you can do it.
But today, what I am
This
saying.
cannot, you cannot do it in this way.
Today, what I am praying, we would have.
You are asked for addition of party. We understand that if you have a writ petition, we'll hear you. No problem on this. These documents were not part of the record before the trial court.
Whatever, Milord, 4 petitions are pending before the Lionel trial. On
You
the
take
basis-
steps accordingly, we will not. Take
Trial
down.
he has to be left 2 minutes. On the basis of the order passed by the Lionel trial judge, Milord, board has uploaded
photo
this
daw,
document in
okhane
the public
photo daw.
domain. These documents are all on public domain.
Otherwise, my lord, let.
4, 5, 6, 7, 8.
Single bench চলে যাও আর আবার চার্জ ওদের কাছে
4, 5, 6, 7, 8. ঠিক আছে?
কি ভুলিয়ে দিয়েছে সুপ্রিম কোর্টের অর্ডার
এখানে করে দেবে same as
বড় জজ ওখানে চলে যা তোরা
same as 190.
শোনে ওখানে
Uh,
Material.
the application for addition of party, the applicant has relied upon documents, documents which were not part of the record before the learned single judge. Full stop. We do not permit disclosure in the manner sought to be made in paragraph 9 of the said petition. However, the applicant shall be at liberty to take appropriate steps in accordance with that.
ওকে কাউন্ট করে না
We have to put an end, otherwise it will continue endlessly. Put an end, otherwise it we will not permit anything. It's a cut-off date, we put a cut-off date, that's all.
এগুলো সেম সেম আছে হ্যাঁ আপনারটা হয়ে গেল
File an application, you shall do it. You file an application. You have others, let them file it. You have others who are supporting you, you are representing them. In that you file it,
others are not
will not. We have given you time, you decide on that. We said this way we cannot. This way we cannot allow this.
Can you help me 1 minute? So far as these documents are concerned, my lord, board has
You
published.
take we are not making you remediless, you take your appropriate steps. We said so. Action থাকবে না, সবই তো dispose of করে দিলাম. One set of same বলে দিলাম. 193
already order passed for hearing paper books have been filed.
Yes. Now tell us,
Paper books are ready, all paper books are ready whenever your lord.
My lord, item number 180.
193 and 194.
180.
Yes, my lord.
Yes.
180, my lord, there are 3 applications. One is intervention, the second one is, my lord, GF. Can 2 is, my lord, the condonation of delay.
No, you are successful or unsuccessful?
Successful, working.
No, but have you served?
Yes,
The list কোথায় আছে?
Application is
Oh, when it is application.
180, but in 137 there is, my lord, no question of condonation of delay.
It's starting from 150.
150, 151, 153, 152. I'm sorry, my lord. 152.
Please just a minute. We একটা সেটা করে দেবে বুঝছো 150 থেকে একবার দেখো তো 150 তাহলে একসাথে করে দেবে সব ট্যাগ just a minute
is also possibly there.
just a minute 150 who is in 150
150 minute I appear for the app.
now what are these applications 1 2 and 3
1, 2 and 3 is leave to appeal, section 5 and 6.
me
Zero.
150 তে একটা হচ্ছে গিয়ে তোমার যেটা এখানে বেসছে ওই একদম তুমি এটাকে ফলো করে যাবে এই অর্ডারে দিলাম না গুরুপদ ওই যে ইন্দ্রজিৎ না তোমাকে যেটা দিলাম ওটা ফলো করে আচ্ছা যেটাতে ডিলে আছে ডিলে যেটাতে ডিলে নেই ঠিক আছে ঠিক আছে লিপ্ত আছে to be heard along with Matt. What is the principal matter you said? Matt, just be heard along with Matt. 890.
আপনার মেন অ্যাকশন 90 আছে
192 আমাদের অ্যাপিল 180
কথা বলছি যেখানে ক্যাম্প 3 পাবে যেখানে ক্যাম্প 3 আছে
198 আমাদেরও মেন অ্যাপিল
192 আমি 193
even 873 is the main matter, my lord.
190 to 193
190 191 192 193 190
193 শুরু হচ্ছে
190 না 189 জয়দীপ আছে 189 থেকে 192
193 তোমার তো।
এনিওয়ে যেখানে হলে আমি আগে আনবো এটা তো argument করবো। পাঁচটা তো আর্গুমেন্ট করবো না।
Just give your appearance. 151. Just give your appearance. এই বিশ্বরূপ দা 150 তোমাদের অ্যাপিয়ারেন্স দিতে বলছি
151 এগুলো।
I think we not status quo. We don't think we not do. Your lordship will not take it up because I am now told one can is section 5, one is a stay. And in the third can, there is an application seeking to add themselves in party in my appeal. That is what my learned friend says.
তাহলে 150 থেকে বাদ দাও।
এখন ওগুলো পরে হোক অন্য
It is better that your lordship takes it up on Wednesday.
150 হচ্ছে যেহেতু হলো একটা
গন্ডগোল হয়ে যাবে তারপরে
সমর্থন করছি
তোকে আমরা সমর্থন করছি ফাইল করে যেটা পার্লামেন্ট কেস থেকে বলে যেটা পার্লামেন্ট
873
আইটেম নাম্বার 192
Milord, item number 195, Milord.
গন্ডগোল হয়ে যাচ্ছে কি আছে বিজেপি আছে কনফারেন্স আছে তো এটাই তো স্বাভাবিক
I want to do this side of the vacation. Give me 2 weeks. We had 4 weeks, my lord. In the initial order, we had this side of the vacation kindly. This side of the vacation difficult.
My lord, may I make one request to Lord? Just a minute. Yes, exactly. That's your lordship's greatness, my lord. Lord, we appreciate, that's your lordship's greatness. Just দাঁড়া একটু বলতে দে না তারপর তুই তো আর জজ হলি না তাই তোকেও বলতাম রিফিউজ করলি চলে এলি টাকা চাই তুমি my lord kindly just this is your greatness, my lord. For what? My lord kindly, my lord. After any day, after 3 weeks, any date, your lordship fix, we can assure to lordship. Let us try our luck.
That is why you kept it today.
No, I am giving the arguments. I have given the notes. Yes, please. I am ready. Let me start it. There are also very reasonable requests of all my junior friends say, let me start it. Thereafter, my lord, we will make a prayer. That's all.
Yes,
His affidavit is required.
absolutely necessary.
Three weeks.
You will kindly take up this side of the vacation.
Never. 3 weeks from date তুমি affidavit ফাইল করো না আগে ওটা তুমি রাজি হয়ে যাও না তারপর তো সেকেন্ডটা তো আমরা
তারপর তো অক্টোবরে ছুটি এসে যাবে।
না তারপর তো আমরা রাজি করব my lord
Very difficult, my lord, kindly make it possible.
my lord so please matter kindly my lord never I have requested my lord
195.
we have a request
That's why you are
no one this is not the matter for this month of
in service. Why you are
my lord sir
you are in service. So you are
no I do not want to open my mouth much. No, yes, I am protected, but I do not want to open to my mouth much. Can you one day? That's a request. One part can be done. Part can be done. No, again, I will remind you, lordship, my lord. Again, part can be done, my lord. Please.
Milord, item number 195.
3 weeks will take us to 25th.
Matt 87.
চুপ করে থাক এটা কার
Within
2 weeks from now.
Who is
Civics affidavit, we will have to study the affidavit in opposition.
reply দিচ্ছ নোটসটা বলছে রিটেন নোটসটা
Written
বলছে
notes,
শর্ট রিটেন নোটস
written 3 weeks from date.
হ্যাঁ পেপার তো করতে তুই পেপারও করিস নি
রিপ্লাই তো হয়নি স্যার আমাদের।
সেটা আলাদা হবে ও তো ও তো আমি শুনবি না শোনাতে হবে
Apples
কবে বললো?
listed,
হ্যাঁ
apples have been listed বলে।
কবে বললো
বোধহয়
কিন্তু-
27th of September.
Very nice. My
Lord, item number 195.
But interim order may be extended, but interim order passed,
There is no
interim order up to September. No, what you are saying?
order of the Supreme Court.
Yes, yes. No, please do not. Well, the interim stay of termination of jobs was till the end of September 2023. This part, yes, till the end of September 2023.
Make it till the disposal of the appeal.
Till the disposal of the appeal.
Yeah, till the disposal of the appeal.
The interim order passed on 19 May 2023
লিখে দিন।
shall continue till the disposal of the appeal.
My lord.
The portion which is not modified by the Supreme Court judge.
ওটা ছেড়ে দেন ওটা বলতে হবে কেন বলার দরকার নেই সেটা সাইড হয়ে গেছে বলবো
মানে করে দাও। Anyway, the interim order with regard to termination of jobs.
কিছু দেওয়ার দরকার নেই
But Supreme
No,
Court.
this is not
Why
necessary.
you-
no please no kindly see because the Supreme Court has not extended. Supreme Court has only set aside a portion of the order. Supreme Court has said
We set aside the impugned interim order of division bench to the extent of issuance of direction to the conduct of selection of.
that part has been set aside, but so far the interim order which is in force up to September, that's not ever been extended.
আচ্ছা ওই যেখানে যেখানে স্টে আছে না, ক্যাম্প 3 আছে না, ক্যাম্প 3
No.
Kindly, kindly.
you filed it late. We fixed it today.
Kindly, if you are limited. Otherwise, not.
কি বললাম?
Otherwise they will
যেখানে বলেছিলাম
go in the street and make
interim order, the interim order passed
না,
19
বলিস
May
না।
2023 so far as it state the termination of job is extended till the disposal
ওটা
of
কি
the
করবে তো সুবীরকে নিয়ে যাচ্ছেন নাকি
till the disposal of the camp 3 এখানে camp 3
সেখানে তো ছুটি
Second October, third October করো।
This order 873 এর আছে sure lead madam বললো না ওখানেই বলে দেবে the interim order passed in this appeal
27 সেপ্টেম্বর কিন্তু
আরে 27 সেপ্টেম্বর থেকে আমাদের আর্গুমেন্ট গুলো হোক না
বললাম তো,
কেন 28 তারিখ তো হবে তাহলে
this order covers
তুই এখনো জানিস 27 বন্ধ কি 28 বন্ধ তুই জানিস
this order covers all the connected appeals.
পরে একটা অরিজিনটা চিঠি করেছে 3 তারিখে
This order covers all the connected appeals with regard to the extension of
জল নেবেন না রাজি যাবেন
ঠিক আছে? You have not filed your notes.
Yes, already.
For the first note you have filed, isn't it? Just
Lordship, may I have two indulgence, Lordship? If
you have filed your notes.
Yes, do not file. Last Monday it was filed.
তুই ফাইল করিস
লাস্ট মানডে মানে
Wisdom.
Yes.
But I have filed my notes.
my lord, we also filed our notes too.
In one matter I have
Some
filed
advocates,
notes.
my lord. the Priyanka Nosko, there are two sets of advocates, my lord.
I don't know, we have only two written notes.
No, my lord, today
One
we have
by
got
you
the-
and the other by
It
you.
was allowed, my lord. It was pleased to allowed by your lordship, some 576, and which was lordship was pleased to allow. We had the two sets of advocates use our oppositions, my lord. And that was also been served, my lord. I have handed over.
We are not allowing any opposition.
No, lordship already allowed.
No, whatever we allowed, we allowed. No
Yes,
further.
no, not further. It has already been allowed.
All
I'm saying-
pleadings. All pleadings stand completed. No further pleadings should be allowed to be filed by either of the parties.
If I want to rely on documents of the board, I'll supply the copy. No,
That is between you and the board.
Yes, I will supply the documents to all the.
All pleadings and disclosures, all pleadings and disclosures with regard to the pending appeals stand or pending appeals stand concluded, and no further disclosure would be allowed, or any additional pleading should be allowed.
Your lordship, to highly direct the board to share the affidavit they're going to file, the scanned copy. If we appellants can get a copy.
No, if the writ petitioners, if the writ petitioner wishes to, like the opposition, any document, board is also give their reply to us also.
Yes.
Because we don't have any scope, we have to read, all that they will give, they will give.
We make it clear now, we make it clear, we make it clear that no further pleadings or disclosure of document shall be allowed any further.
তুমি কি অযোধ্যা যাবে?
February,
আমি বছরে দুবার যাই।
on behalf of,
ও মন্দির
divide amongst yourself who is
Yes, your
appearing for whom.
Not divided.
গিয়ে 2 তারিখে।
No, he said he's representing few on the other day.
And rest
So
are
now
representing
between you decide who is representing
Some of
whom.
the respondents, well, that is, there is one number three.
No, all writ petitioners you are
Yes, your lordship. Rest are for the us.
Some of the.
submit.
Your lordship, a fixed appeal on.
Submits that there are few documents that may be relevant for the purpose of deciding the issue, and those documents are all published by the board.
3rd of October.
In the event, in the event the petitioners want to rely upon any documents of the board in the appeal, the same should be supplied to, who is the advocate on record?
Mr. Atul,
Mr. Atul Vishwash, within a week from date.
No, again new documents.
No, he said board's document.
Pardon?
Board's document, boards.
Key documents? No, these documents are not.
Maybe we are appeal court. We are appeal court. But so we have to decide the matter. So if these are found relevant,
Things will not be ended.
we only said permit him to rely upon any document of the board which he finds relevant within 1 week, no further. No private document.
Just now, your lordships have rejected their applications.
You have rejected the application, that application you have rejected.
My lord, they rely upon the documents of the board, in the name of documents of the board, my lord, they, my lord, compile, my lord, make some compilation. My lord, out of, my lord, from the website of the board. My lord, that we have to verify, my lord, it will take, my lord, much time. my
Last
lord.
time,
No.
no, not at this stage, not at.
No.
We'll decide, see, the propriety of the order, the propriety of the order of the trial court has to decide on the basis of the documents available.
Kindly has me wanted. Your lordship, that will not.
Let us start the hearing.
Documents are genuine documents. There are documents.
Your date of hearing.
Item number 190,
Your date of hearing from the appeal.
195, my lord.
Seven.
I'll be,
Yes.
My lord, item,
Lot for record be called for.
I'll be out of town from 27th to 2nd. Kindly fix it on 3rd or 4th month, whatever is convenient.
October is very difficult.
27th, I will not be here, my lord. From 27th, I'll come back on 2nd.
Last week is very difficult.
And these,
Last week, no.
we are-
Our week is
20th. We will be closing on 20th. Kindly take it on 3rd.
May I submit one thing, Lord?
Document is there before the trial court, that's all.
Yes,
It's not
Lord,
allowed-
I will not use any document which are not there before the trial court.
No, we'll not. Trial court record will be here if it is not, so that's all. You can refer to the trial court record, we have no problem.
Now, my lord, may I?
Shunu, original record of,
No, date.
the original record of
The trial court in
The
petition.
original record of WP number. Yeah, আছে?
WB numberটা কত ছিল?
Shall be produced.
না, না,
1887.
2187 of 2022.
Shall be produced. Shall be produced on the date of hearing of the appeal. Yes.
2187 of 2022 is the writ petition.
Miller, item number 195, Miller. Miller,
Yes, WP number.
WB 187 of 2022.
21187.
এই দেখো দেখেন। Vacation.
Not we don't third minute can.
Let us argue for it.
Fix 3 days consecutively and here's it. Not instead of not a
Then
hearing.
we have to deliver the judgment. We have to think of it.
3 days.
So we'll have no time to think.
Your third kindly fix it.
Consecutively, you'll also heard the matter.
But that is convenient of the court, Miller. That's your losses convenient, Miller. When the consecutive or non-consecutive or executive, that court will
But
sit.
once we start, we'll.
Yes, yes, yes,
Yeah,
yes, yes.
of the party.
When we are remaining the 3 week matter should be there.
Once we start.
Yes, 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 yes.
Any idea?
Absolutely correct, Miller. No, you will not take much time to your losses.
তাহলে তোমার এ করে দেবে third করে দাও
Millard,
3rd
we-
October. But all of you should file your notes.
Yes.
Notes করে দেবে সবাই notes file করবে by 25th of September.
Yes, 3 weeks. 20.
Well, I have given, Miller, if I feel, Miller, in addition, if I want.
Is there with a proper back sheet with compilation of cases.
পঁচিশে তো সবাই দিতে পারি।
You have referred to cases, but you have not given those cases.
I have given, no, judgments I have not handed over.
No, in the compilation it's easier.
I will make the compilation. I will come up with the compilation.
So you also, all of you.
No, if I can take it back, what I want.
Let all of us file on 25th.
No, why I have not handed it?
First file it on 25th.
Why I have not handed it to losses court, considering this, if I file the compilation now, paper books are heavy. Well, it will be impossible to handle.
No, it is one part of it because we can handle our notes separately.
Notes is all right.
Nothing with the paper book.
No, notes and the compilation, I will give it. But sometimes after reading.
I know, I tell you, compilation is easier because at one place it will be there. Otherwise, if you.
I will the compilation. I will handle the compilation.
Item number 180, there are 3 applications. Identical orders should be passed, my lord.
But who is in 180?
180.
You are there, Mr. You are there. In 180, you are there. Yes.
No,
you are the
Suraj is to
respondent
180
there. তাহলে গুরুপদ 180 তে না এটা স্টে এর যে অর্ডারটা হবে সেটা হচ্ছে সেম অ্যাজ স্ট্যাম্প 3 অফ item number 188 ঠিক আছে
And in 137, my lord, there is only one application, leave to, my lord, prefer the appeal. There is no question of condonation of.
137.
Yes.
Yes, you have been served with 137.
Yes, served, my lord.
137.
I'm told, my lord, it has been served.
137 and leave to prefer an appeal should be.
May I have one?
Leave to prefer an appeal order should be. Application গুলো নিষ্পত্তি করে আবার এখানে এগুলো সমস্ত একবার দাঁড়াও তো ব্যাস ঠিক আছে ব্যাস
Lordship, just one prayer.
137 এর শুধু আছে বোধহয় 137 who is in 137
137, my lord.
is only leave to prefer an appeal.
Yes, only.
And Lordship, there is one appeal which could not be listed today. 1665 could come up successfully registered with CAN 1 and CAN.
As and when it appears.
As and when.
As and when it appears.
Or it could come up on the next day.
Whenever it appears.
আবার তার আগেই চলে আসবে।
If I may just hand over the slip, Lordship.
to come along with, to come up along with this.
Have been granted, my lord, leave to prefer an appeal. My lord, possibly this is the shortest matter, my lord, in this bunch of matters my lords have. My lord, I am representing the para teachers against whom, my lord, my learned friends have no allegation. No one has any allegation, but my lord, I am in the crossfire.
certain points. Para
It has
teachers are
to.
given,
Acha.
para teachers are given mark in fraction.
Acha.
Yes.
So if you kindly allow us, my lord.
You are in such a great position.
এইটাই
After
190
6
to
years,
193 এগুলোর সঙ্গে
You
যাবে।
were unsuccessful.
Made public domain on
You were
November
unsuccessful.
2022.
You were unsuccessful, untrained. And after 6 years, you came.
Just made the public
And-
domain on November 2022.
My lord, that is the point, my lord. Kindly appreciate the, my lord, the point is,
Absolute fraud has been committed.
my lord,
If it is a fraud, it's a fraud.
my lord, kindly appreciate the point is there. Kindly appreciate this, my lord. If you are on a ground that understand this, my lord. Even you have to sue because this is not notable. So while hearing the suit or hearing the proceeding, if anything comes, that can, blood delay can be condoned. এই পড়ে যাবে জজ সাহেব, এই ফাইলটা পড়ে যাবে জজ সাহেব, এটা মানে সুপ্রিম কোর্ট স্টাইল দিস ওয়ান। মাননীয় জাস্টিস গুপ্তা কুমার, মাননীয় জাস্টিস কুমার, that is exactly Supreme Court style.
কথা বললো।
In my appeal, if my lords kindly dispose of the application and my lord hears.
No,
But in my appeal, there is an application. My lord, in item number 195.
কোনো application নেই।
195 এ কিছু নেই। আরেকটা application আছে। Can to is
Well, on 3rd October at least, no other things, only on merit, on argument on the merit on the appeal,
Yes,
not this and that. Hopefully.
I follow the footmark of my learned senior friend, my lord. My
No.
application kindly dispose of, kindly allow me, my lord, to press the appeal. But can two, my lord, I am told is pending. Wait, no, I stand corrected.
বিপ্লব লেগে। এখন কিচ্ছু দেখি না।
Grateful.
এই পেনটা কার রে? এ রেখেছি তো।
আমি আপনাকে একটা মেসেজ পাঠিয়ে দেবো। আমার নাম জয়দীপ। আর কোনো মামলা দেবেন জোসেফ না? I had going to login. আজকের দেখে না ঠিক আছে পরে 196 হ্যাঁ তার চলে গেলাম বসে থেকে চলবে না কিন্তু হ্যাঁ এটা চলবে না আমরা কি রাখবো সত্যি চালাচ্ছি হ্যাঁ ঠিক আছে চলবে তারপরে 197 আমি 197 আমি কেন বলবেন
হ্যাঁ, স্যারেরও নামটা হয়েছে, আমিও বেঁচে স্যার আছে আমার কাছে একটা কপি আছে।
Before your lordship takes up the 196, at 197, the appellant possibly they are not willing to proceed with.
My lord.
Because the appeal has become infructuous. If your lordship then.
Yes, my lord, I have
96
taken
I-
instruction, matter, nothing remains in this matter, everything, my lord. I have taken instruction. No, no, all the benefits, approval given, they are in service, my lord.
Writ petitioner respondent. So, my. They implemented the order.
Yes, yes.
Where is your instruction?
They have not given over telephone, they inform me.
আমি রিট পিটিশনার রেসপন্ডেন্ট 197 198 দুটো তাই তো দুটো তো হ্যাঁ আরে ও তো না না তুমি আর স্যার করেছো বারেন্দ্র 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 বারেন্দ্র
আলো লোক
দাম ও আচ্ছা হ্যাঁ হ্যাঁ
197 আপনারাই দিয়েছেন, আর কিছু নেই, ওরাও দিতে
ঠিক আছে না 198 না
সেকেন্ড কপিটা নেই।
190
সেকেন্ড
না।
একটাই আছে।
কিন্তু এটা সিটি আছে ঠিক আছে দুটোতে এনগেজ নন,
কিন্তু কপি তো পেয়েছি একটা,
আপনার দুটোতে ইনস্ট্রাকশন নেই,
ফোনে কিছু রিটেন কিছু ইনস্ট্রাকশন দেয়।
অস্বীকার করবে না তো ওরা?
না,
Similar
matter.
Deeply obliged.
I'm deeply obliged.
Well, I pay for the appellant. Appellant, private respondent. Private respondent in the writ petition. That
Lord, I am appearing on behalf of state respondent.
Pursuant to your lordship's order, my lord, I have already served the copy of the paper book. This huge paper book to the others. আমারই তো no objection brief, আমি তো ছিলাম না মামলায়। পেপার বুক দিচ্ছি এত মোটা দেখে ভালো লাগছে। না না চলে যা may I start? This is regarding approval of the appointment of organizing staff in a language group. The appellant before your lordship was the private respondent number 7 in the writ petition. Now the impugned judgment at page 42. 42 of the paper book. On the strength of the order of this judgment, the approval that I got, which was I got the approval in terms of the order of the Commissioner of School Education at page 42, by which the approval of appointment of the writ petitioner was confirmed. But this order was set aside by the Hon'ble single bench.
Petitioner confirmed respondent number 7.
Respondent number 7. Well, the judgment under appeal before your lordship is at page 236. And I joined the school. I received the salary. Thereafter, the judgment of the Honorable Single Bench, it came and I lost my job. Well, your lordship kindly sees page 46 once. But in language group, it's a 1998 circular. Distribution of teaching staff in a recognized non-government junior high school. But when I joined there, it was a junior high school. Your lordship is at page 46. For junior high school, high madrasa, language group, 2 posts. But I got my appointment in one of the posts in language group. Page 91 is my approval. Page 91 is my appointment on 26th of April 1990. Issued by the Secretary of the Junior High School. Number 91. Now, my lord, your lordship, on the last day, when I moved this petition, moved this appeal, my lord, I presented 3-4 pages of the division bench judgment, starting from page 71. This is very important. Let your lordship kindly have a look to page 79 of the paperwork. My lord, this is the view of the division bench judgment. Because, my lord, the only point of consideration is that whether, my lord, before the district level inspection team, my lord, I was present. Whether, my lord, I was present or not. My lord, this has been taken care of by the Hon'ble Division Bench at page 79. My lord, kindly have a look to page 79. And on the strength of the Division Bench's order, my lord, the commissioner has passed the order by which, my lord, my appointment was confirmed. Your lordship is reading page 79. On perusal of the documents of the parties, we further get that the appointment of respondent number 13 was illegal, and in fact, the writ petitioner appellant was the second teacher of the language group at the time when the DLIT held inspection. We further find from the record that the staff pattern which was presented before the DLIT India 99 was not correct, and in fact, the resolution through which the staff pattern was prepared was an illegal resolution, and the DLIT was not correct in recording its recommendation on the basis of such illegal resolution regarding staff pattern of the school. On analysis of the order of the Director of School Education, we find that the Director of School Education did not take the trouble of verifying the actual position with reference to the attendance register of the school between the period 1990 and 99, and on false pretext, the Director of School Education exonerated the Secretary of the school from producing the relevant documents. Thus, having regard to the entire fact and circumstances and with reference to the documents produced and relying on by the appellant petitioner as well as by the respondent number 6, we find that neither the respondent number 5 and the respondent number 9, 12 and 13 have succeeded in controverting those documents which would go to show that the school authority, by adopting fraudulent means, showed such persons as teachers who were in no way connected with the affair of the school, and naturally the staff pattern presented before the DLIT was far from true, and hence the DLIT report was not acceptable, and the authority concerned was not justified in according approval to the teachers on the basis of the report of the DLIT. But kindly, I pause here for a moment. But your lordship will find these persons at 9, 12 and 13. But 9 is page 70. 9 is Safikul Haq, 10 is Torun Kanti Pal, and 13 is Sajjad Hussain. Page 70. Constantly. But against this Sajjad is the writ petitioner, against which, against whose order I have come before your lordship. Now, Sajjad's appointment was under challenge. The court found that in view of what has been stated above, we are of clear opinion that the report of the Director of School Education pursuant to the direction of the learned single judge was not correct, and hence the learned single judge was not justified in accepting such report and turning down the legal claim of the writ petitioner appellant. Accordingly, having regard to the submission of the rival parties and with reference to the documents on record, we are of the view that there is merit in the present appeal, but I was the appellant, and the order of the learned single judge cannot be supported at all. We accordingly allow this so and so thereafter. As we find merit in the contention of the writ petitioner appellant, we are inclined to make a stay stay order regarding appointment of 9, 12 and 13. Absolute. And the modification application filed by the respondent number 9, 12 and 13 being so is accordingly dismissed. Thereafter, we are also inclined to quash the order of the Director of School Education dated 29th of May 2002, and we direct the Director of School Education to hold a fresh inquiry after spot verification through a competent officer and to decide after hearing all interested parties and on examination of all relevant documents who were actually organizing teacher at the time of approval of the school in the year 99. And after holding such inquiry, the Director of School Education would pass necessary and other necessary order regarding fresh approval of the actual teachers of the school, including the writ petition appellant. But I was the writ petition appellant. The Director of School Education is directed to hold such inquiry and to submit his report, and thereafter to make a fresh approval, so and so. Now, your Lordship, kindly have a look to the Director's order, which has been passed in compliance of the division bench's order. So, may I once again, for the risk of repetition, may I say that the may I please, that the appointment of the private writ petitioner appellant, the writ petitioner respondent was absolutely illegal. That is the specific direction of the court that Sajjad Hossain has been illegally appointed. Now, your Lordship, kindly have a look to the order of the Director of School Education, starting from page 42. Minute 44. It said the following questions have been raised in this issue: whether Shahana Begum, I am Shahana Begum, was appointed on 26th of April 1990 as organizer teacher; whether Sajjad Hossain, organizer teacher of language group, was actually appointed on 20th March 1990 in order to show him as a senior to Shahana; whether so-and-so, ex-managing committee member of the school, had died on 3rd of May 1993 or any subsequent date; whether the DLIT team was correct regarding recording the name of the organizing staff during their DLIT inspection of 3rd of November 1998. Thereafter, it has been established that the actual date of appointment of Shahana Begum is page 44. 44. It has been established that the actual date of appointment of Shahana Begum is 26th of April 1990 as non-disputed to it. It is a fact that Sajjad Hossain is the son of ex-secretary of the school, which was not very much important here, but it appears that circumstantial evidence that the date of appointment of Sajjad has been shown as 20th March 1990 in the record placed before the DLIT team on 3rd of November 1998. The original attendance register and the managing committee meeting resolution book for the period of 1990 to 1999 has not been placed before the inquiry team as well as before me, which means that the date of appointment of Sajjad being 20th March 1990 senior to Shahana has not been established. Only letter of appointment cannot prove the original date of appointment and joining. A diary was lodged for missing of some school documents before the police on 28th of June 2000. Whereas they had assured on 9th of April 2001 before the Director of School Education to produce original attendance register and the resolution book on 13th of May 2002 on the next date of hearing. In fact, the missing of those original documents had been reported on 30th May 2002 before the Director of School Education. Therefore, the actual loss of those two documents for the period of 1990 to 1999 has not been properly established. Then, the school authority admitted during inquiry that Shahana was present on the date of DLT inspection held on 3rd of November 98, and her name was not recorded as she was the third teacher in language group and seventh in the position of teaching staff. It may be so that the records in support of those contention was placed before the DLT team. However, it seems to me that it is a case of manipulation. The original records have been suppressed and new records appear to have been produced before the DLIT with a motive to show Sajjad Hossain as senior to Shahana Begum. The actual date of death of Mohammad Swanso has been confirmed by the SDO Barashat on 3rd of May 93 in terms of his report received by memo number Swanso. Therefore, in case of appointment of Safikul Haq, assistant teacher, and Aklima Khatun, class 4 staff, but I am not concerned about it, was manipulation, but that does not affect the claim of Shahana. Perhaps the DLIT team report was on the basis of the records as produced before them, but there were sufficient grounds in support of the fact that Srimati Shahana Begum served the school prior to recognition and after recognition. These are very important. Then, the date of appointment of Sajjad Hossain has not been proved as 20th March 1990, and on the other hand, his date of appointment of 20th March 1991 has not been disproved. I think there are some veracity on the affidavit dated 29th of April 2003 and 29th of January 95 of Muzaffar Hussain and Maqsood Ali, the present managing committee members, to the effect that the name of Shahana were excluded from the DLIT report in order to give birth to Sajjad Hossain. On the other hand, the name of Sajjad Hossain, assistant teacher Saiful Swanso, appears in the DLIT team, leading to recognition of the school. As per the previous rules, their appointment had been approved. But in terms of Geo number Swanso, the organizing staff cannot claim approval as organizing staff teachers in their case, as the school did not pay requisite fees along with their application for recognition before the West Bengal Board of Secondary Education prior to 1975. Therefore, it cannot be said that the rules have been strictly followed in the matter of approval of organizing teacher. From the above finding, I hold that the appointment of Saiful, assistant teacher, Sajjad Hossain, assistant teacher, and Aklima Khatun, class 4 staff, as organizing staff had been made by the school authority by way of manipulation. The degree of manipulation is such higher in case of Sajjad Hossain in comparison to other two staffs. I therefore allow the approval of Safikul, assistant teacher, Aklima, class 4, and set aside the approval of Sajjad Hossain, assistant teacher. The district inspector of schools, SC North 24 Pargana, is directed to withdraw the approval of Sajjad Hossain and accord in favor of Shahana Begum as assistant teacher. But this order was challenged before Justice Dotto. This order has come after the division bench has found them illegal. The division bench, I placed before your lordship that in the judgment of the division bench has categorically mentioned that these three appointments are illegal. And the interesting part is 89, page 89. They have filed a review petition before the division bench. That was also dismissed. 89 and 90.
Not disposed of, not dismissed.
Disposed of without any order.
None. Hello.
Having regard to the submission put forward by Mr. Swanso appears on behalf of the petitioner in both the review application, and having regard to the submission made on behalf of the opposite parties, we feel that there is no scope for any review of the of our ultimate direction given to the Director of School Education, holding verification of the entire affair relating to the appointment of the organizing teachers through the report of the director submitted earlier. Then
next.
Yes, we however are very much impressed with the submission made by Mr. Chatterjee. Mr. Chatterjee appeared for 9, 12 and 1. Very good. That some of the observations of our in the body of the judgment might create some confusion in the mind of the officers holding such inspection, and for that purpose to remove all doubts in the mind of the petitioner and also the opposite parties, we will who will be actively participating in the inspection process, we make it clear that our observation touching the earlier appointment of the review petitioners shall have no bearing on the inspection team, and also admittedly the court said that no, our observation will not have any bearing effect on the inspection team. But what the inspection team found and what is the order of the Commissioner of School Education? The period from 90 to 99 found missing. After the division bench, when the division bench directed the commissioner to cause an inquiry and a fresh jail team. Now your lordship kindly have a look to, may I? Shall I continue or melody start today? Your lordship is about to dictate the order. Very well, kindly then.
Yes.
Well, I think Justice Datta's judgment is a complete answer to all my learned friends. It's a complete answer.
Then, may I be permitted to place Justice Datta's judgment for once?
Yes, please.
236. Page 2.
Yes.
Page 239, internal page 4 of the judgment. But I'm reading the judgment in parts because full judgment is more than 25 pages.
Each observation is that's true, it's the appeal. You are dealing with the life of the persons. Because it was heard for 4 days, not 1 day.
Page
basically from page 12, paragraph the observation of the director. Internal page 12 of the from memo of appeal.
But few judgments have been, portion of the judgment have been quoted. I'm skipping those parts. Because the entire order of the director has been quoted. So I'm not reading that part.
You read from the observation of the director.
Lordship.
She was also shown below her in rank.
Absolutely.
So if there are 6 teachers, he's a 7.
But question of whether I'm below the rank or not doesn't come because in language group, whether I'm posted in language group or any other group. In language group, I'm 2.
No.
I'm 3. If Sajjad goes, I can make an entry. Simple. In language group, there are 3 posts. If Sajjad's appointment is strike out, then I have an entry. And till date, my lord, I'm working over there in the school. Yes, yes. No, not approved, but I'm working in the school. Now, my lord, your lordship kindly.
My lord, may I make one submission? Of course, it's, my lord, may give some solace to my learned friend client. On merit, I believe, my lord, she doesn't have any claim. My lord, there are vacancies in the school, I'm told. My lord, she was present, but she was a third teacher. According to the staff pattern, cannot come. So, my lord, since she was present, whether he is rendering duty unapproved or approved not, there are vacancies. If your lordships direct the authorities to consider her, considering this situation, I am not standing in it. That would be the best, my lord.
How it can be now because of the, my lord, school service?
Then, my lord, send out. Then
because of this, my lord, inception of the School Service Commission Act.
by your lordship's order, because this is an organizing school, not by the stateway, go by the law, School Service Commission, she can't get in entry.
No, but organizing school, the concept of organizing
No longer there.
No longer
No
there.
longer there. But at that point of time, everybody did it. Organizing teaching.
that is on the basis of the DLIT reports.
Absolutely. Absolutely.
But I tell you, lordship, in primary, under the rules, there was a conception of organizer teacher. Admittedly, Rule 4A of 1930. In the secondary education, not under the rules, but all by government orders. And that was the accepted situation. But executive order sometimes takes place the provisions of statutory law. And that has been followed. That's why I'm saying, my lord. If my learned friend thrown on merit that.
No, but how, even if we pass an order, how it could be after the School Service Commission Act, how it could be done?
My lord, no, I'm not on the, my lord, school service, because this is a case before School Service Commission Act. In that view of the matter, your losses can.
No, in school service at that time, even then, there has to be a requirement of an approval.
That's true. No. Now this has to be done considering the fact.
No, even at that point of time, it was not approved. If those posts were approved.
Absolutely, by the board.
No, I tell you, post were approved. This conception, I differ with the judgments of our High Court. In organizing cases, as soon as the school is recognized, posts come with the recognition.
Yes, but how many? That's the point.
According to the staff pattern situation, if a junior high school 6.
So whether the staff pattern at that relevant point of time
did not permit her.
Then
that's my lord. That, my lord, if you go by strict sense, my lord, not.
That is why I asked.
Strict sense, not. If your losses give some, my lord, equitable, my lord, preference, that your losses can. Otherwise, she can't have any entry. Well, it's elaborately argued and very nicely dealt with. I request my learned friend to show the defect in the judgment before the appeal court.
Absolutely.
That's the only thing.
That's why I'm here.
Do that.
But
yes.
But if before going into the details of the judgment, what Mr. Shanal has said before your lordship, it can be in a sympathetic way, but it can be. No. It can be considered in that light, because if I don't have an entry, I will not get the approval. Chinese food. Now, if I have entry, then only I have an approval, and that too at the cost of Sajjad.
If you have an entry, then Sajjad goes.
That cannot be found.
Absolutely.
Because her own claim in the earlier writ petition also that she is third.
She is third, but the report of the commissioner is absolutely. You are supporting the order of the single bench, and I am opposing. I'm supporting the order of the commissioner. The commissioner is the fact-finding authority, not the court. Number the ground level reality has been mentioned in detail by the commissioner. Kindly have a look to the commissioner's report once. Then I will come to the judgment of Justice Datto. Definitely, I'm here to deal with the judgment. Kindly look to the commissioner's approach and the earlier division bench's observation. We cannot forget, we cannot forego the other division bench's observation based on which the commissioner's order was passed.
বোধহয় দেখ স্কুলে ওইটা যে এখন হচ্ছে স্কুলের দিকে যাচ্ছে দিদি বলতে স্টেপ ইনস্ট্রাকশন যদি আসেও না থাকে সোশ্যাল সায়েন্স গ্রুপে দিয়ে সব সাবজেক্ট এখানে কোর্টকে একটু বলুন আরে এবার আমাদের সাথে বলুন পেলে সায়েন্স কি করতে
But the original letter of appointments were produced.
yes produced
The original
and that
letter
has
of
been recorded
appointment,
your loss.
Shahana was shown 26th April and Sajad is shown 20th of March.
Now, my lord, page 239, third paragraph, your losses will be getting it.
239.
239. My lord, internal page 4 of the order. Admittedly, Sahana was seventh teacher. That was her abhorrent also, all throughout.
No, but at the same time, the school authority admitted during inquiry that Shahana was present on the date of VLIT inspection.
I tell you, lordships. Yes. Sahana, this fact should not be denied. Seventh teacher, but seventh teacher cannot be kept in the DLAT report because of the staff pattern. Clear to losses?
No, it is one thing to say, mention the name, staff pattern.
I tell you, lords, that's why I am saying, that's why I wanted to, my lord, in favor of the relief to some extent, if now vacancy is there. But he or she was an organizer
The
teacher.
vacancy now, then because of 97 Act, it cannot be filled.
I
by
buy off the lawsuits order, otherwise not. Other strict provisions of law applies, my lord, she can't get into it. My lord, this happened at that point of time. There are my lord, junior high school, there are 10 teachers. So 10 cannot have approval. There are orders your lawsuits will find if subsequent vacancy arises, the next man will get it. This sort of order we also obtain from this honorable court. So keeping in that view, I am saying, your loss to give some relief. Actually, Sahana came before this honorable court questioning the appointment of the respondent number 8 in the earlier writ petition, where her avowment was total admission that he was the third teacher in our school. See rather, sir.
Now, my lord, kindly have a look to page 78. The finding of the division bench.
But for Sajad Hussain, there cannot be 2 dates of appointment.
Pardon.
For Sajad Hussain, there cannot be 2 dates of appointment.
No, there is no 2 dates.
No, if you see page 44
Page 44 of your judgment
of the paper book.
paper. Yes, madam.
The date
Page
of appointment.
44, page 44 only is missing. Just your losses will find
Last but one paragraph.
the date of appointment has not been proved.
No.
This is wrong finding first.
No, the date of appointment of Sajad has not been proved as 20th March 90. And on the other hand, his date of appointment as 20th March.
No, there is nothing. There is nothing on that date. Nothing. Malad, this was the date of appointment 20th March 1990. And this has been proved before the learned single judge. Malad, here, Malad, all the documents are not there. even the avowment of the Sahana in the earlier writ petition before this honorable court, 2 successive writ petitions, her representation also.
2 affidavits were filed by Muzaffar Hussain
And these are things your losses always find in organizer school managing committee members. Rival malar interest, they sometimes enter into. So these have been dealt with malar in the judgment.
But this issue has been dealt with by the division bench also earlier.
The division bench didn't have all the documents. That's my case.
Yes.
Now, your lordship, kindly have a look to page 78. Kindly have a look to page 78, last paragraph.
Page 78.
Yes. After comparing the documents produced and relying on by the writ petitioner appellant, the respondent number 6, respondent number 5, we are of the clear view that Jabbar Ali was dead on 22nd September 1993, and we are of further view that the documents produced by the respondent number 5 in connection with the death of Jabbar Ali are all forged and fabricated document. Then, on the perusal of the documents of parties, we further get that the appointment of the respondent number 13, that is Sajjad, was illegal one, and in fact, the writ petitioner appellant was the second teacher of the language group at the time when the DLIT held the inspection. This is the finding of the division bench. Then we further find from the record that the staff pattern which was presented before the DLIT in the year 99 was not correct. So, my lord, whether I am 6, I am 7, I am 2, I am 3, if the staff pattern is not correctly followed and presented before the DLIT, my lord, I may be the 11th, I may hold the rank of 11. The court, that is why, finding this malpractice, the court once again directed the commissioner to hold the fresh inquiry. This finding of the division bench has not been dealt with properly by the honorable single bench. This is my humble submission before your lordship. Kindly have a look to the honorable single bench's finding, whether these portion of the division bench's finding had been properly dealt with or not. These are all facts on affidavit. The interesting part is next, page 79. On analysis of the order of the director, we find that the director of school education did not take the trouble of verifying the actual position with reference to the attendance register of the school between the period 1990 to 99, and on false pretext, the director exonerated the secretary of the school from producing the relevant documents. Similar when I was appointed. Sajjad was appointed on 20th March 1990, and I was appointed in April, 20th April. So from period 1990 to 1999, the attendance register was not there. Who will prove that I was present or he was present? Who got the appointment? These private, all are privately managed.
মেনটা আছে
No, but what do you say to this? The appointment letter of Shahana, her letters of 31st December 94 and 1st January 95, and the copy of the daily attendance register for the month of such are sufficient to establish that Shahana at the time of her appointment was a seventh teacher.
My
while
lord is reading
Sajad was a
page.
sixth.
My lord is reading
Internal
page.
page 12 of the judgment.
12 of this. 130. It's 236. Part এটা কি 1 নম্বরে থাকবে ফার্স্ট ম্যাটার
কখন নেন সকালে
সকালে সকালে সেকেন্ড সেকেন্ড মানে হয় না মোশন গুলো আটকে যাবে সব let me try to satisfy your lordship grateful কালকে